D'accord. Bah, s'il veut étudier le décret, c'est qu'il n'accepte pas la juridiction.
Buenos días.
Buenos días.
Buenos días, señor presidente, Dr. Stern, Mr. Dreimer, how are you this morning?
Muy buenos días, doctor Hamilton. Buenos días, embajador. ¿Cómo está usted? Doctor Llano, doctora Popova, doctor Gijón. Cuando la secretaria nos diga que está todo el mundo presente, comenzamos. Veo ahora al doctor Friedman también, doctor Rill.
Sí, tenemos los representantes de las dos partes conectados y también tenemos a representantes de la parte no contendiente, Mr. John Daly y Miss Maggie Sedgwick.
Muy bien, muchas gracias, señora secretaria. Comenzamos la audiencia. Este es el segundo día en la audiencia final en el arbitraje bajo el reglamento UNCITRAL entre Gramercy Funds Management LLC y Gramercy Peru Holdings LLC y la República del Perú. Les doy la bienvenida en nombre del tribunal en este segundo y último día de nuestras audiencias. En primer lugar, vamos a preguntar si hubiera algún punto de orden del día y si no, ya le damos la palabra a la representación letrada del Perú. Is there any point of order, Mr. Friedman?
None from claimant side. Thank you. Good morning, Mr. President, members of the tribunal. And good afternoon. Good afternoon, sorry, to those of you in Europe.
Thank you, Mr. Friedman. Y le preguntamos ahora al doctor Hamilton. Doctor Hamilton, ¿algún punto de orden en nombre de la demandada?
No, señor presidente. Muchas gracias por la pregunta. Estamos listos.
Muy bien. Pues entonces comenzamos la audiencia. Tiene la palabra la representación letrada de la República del Perú para su presentación de conclusiones. Y tenemos que darle número a este documento de la República del Perú y le damos el número H22, señora secretaria. No se le oye, señora.
Perdón, sí, H22.
H22, muy bien.
If we might ask non-participants in the oral argument to close their video other than the tribunal and señor embajador, si puede abrir el video. Muy bien. Mr. President and members of the tribunal, on behalf of the Republic of Peru, Whiting Case and Estudio Rubio, it is my pleasure to commence the closing statement of the Republic of Peru with respect to the proceeding of Gramercy v. Peru. It is important at the outset of the closing statement that we keep in mind that this is a case under a treaty. Yesterday, we heard the treaty cited out of context, leaving out words, leaving out meaning, disregarding the object and purpose. Next slide, please. And there were two things that we heard very little about in Gramercy's closing statement. Not only did they disregard the object, purpose, and plain language of the treaty, they also disregarded the opinion of Yale University professor Michael Reisman. Professor Reisman, an eminent scholar in the field of investment arbitration law, is the only international law expert before this tribunal. Gramercy chose not to present an international law expert. Indeed, they tried to exclude Professor Reisman's participation late in this proceeding. But his testimony stands before the tribunal nonetheless. And as he emphasized in his first report, by initiating arbitration under the treaty, Gramercy has subjected itself to the norms regulating the ISDS system and the integrity of the arbitration process, including specific requirements set forth under the treaty itself. During the course of Peru's closing statement, we will probe this issue with respect to the meaning of the treaty, with respect to Gramercy's conduct, taking into account the requirements of the treaty, and Gramercy's conduct outside the sacred confines of this treaty proceeding, which also have serious ramifications for its claims. And the other thing that Gramercy did not discuss is the submission by the non-disputing party, the United States government, and we will discuss that in detail. Keep in mind, with respect to the treaty, that it was carefully negotiated by the Republic of Peru with the aim of facilitating good commercial relations between the United States and Peru, and to facilitate commercial investment, commercial activity and investment. I would like to invite the Ambassador of Peru, Hugo de Zela, to share various additional comments related to the U.S.-Peru treaty. And the Ambassador will speak in Spanish.
Very good. Muchas gracias. Señor embajador, tiene la palabra.
Muchas gracias. Buenos días, señor presidente, honorables miembros del tribunal, señoras y señores. Mi nombre es Hugo de Zela, soy el embajador de la República del Perú ante los Estados Unidos de América. Y me dirijo a ustedes el día de hoy en representación de mi país, Perú, como parte de sus alegatos finales. Al respecto, quisiera hacer 3 observaciones que consideramos importantes. La primera, el acuerdo de promoción comercial entre el Perú y los Estados Unidos tiene una alta importancia para la relación bilateral entre nuestros países. El tratado beneficia a los peruanos y norteamericanos, favoreciendo el desarrollo de sus pueblos. Respetamos los mecanismos de solución de controversias internacionales y participamos diligentemente en ellas, como lo venimos haciendo en este proceso. Queremos también hacer notar la relevancia de la interpretación del tratado por parte del Perú y de los Estados Unidos. En segundo lugar, el Perú es un estado que ha demostrado un manejo macroeconómico responsable, seguridad jurídica y una sólida disciplina fiscal, factores que han contribuido a posicionarlo como uno de los mercados más confiables para inversionistas en la región y a alcanzar una de las tasas de crecimiento económico más altas en Latinoamérica. El comportamiento del Estado peruano en esta línea ha sido consistente durante décadas, más allá de transiciones y cambios políticos, y el Perú ha mantenido una política macroeconómica estable, respetada aquí en Washington y en los mercados internacionales durante muchos años. Un ejemplo de la institucionalidad y respeto por los mandatos legales es el establecimiento de un procedimiento para el pago de los bonos de la reforma agraria. Dichos bonos involucran antecedentes históricos y únicos, cuyo tratamiento por el Estado peruano se ha realizado en cumplimiento de lo dispuesto por ley. En tercer lugar, el Perú comparte con Estados Unidos la visión de la importancia de sus obligaciones internacionales y la expectativa razonable de que este procedimiento se resuelva transparentemente conforme a los términos del acuerdo comercial suscrito por los dos estados y las interpretaciones comunes realizadas por ellos. En ese sentido, lamentamos la insistencia de la contraparte para excluir repetidamente a los representantes de los Estados Unidos e impedir que reciban toda la evidencia y observen los procedimientos orales en su totalidad. Además, para el gobierno peruano, ha sido motivo de preocupación la campaña de desinformación que ha pretendido ejercer una presión contra el Estado peruano para lograr cambios en su legislación interna, así como para oponerlo frente a la opinión pública y ante el gobierno de los Estados Unidos e instituciones multilaterales. Al mismo tiempo que agradezco la gentil atención brindada por los señores miembros de este tribunal, me permito respetuosamente poner bajo su consideración las referidas observaciones, que tienen por objeto mostrar la seriedad y responsabilidad del Estado peruano en el tratamiento de esta materia, así como rechazar conductas que socavan el acuerdo comercial y Estados Unidos, las cuales perjudican los esfuerzos de colaboración de nuestros países en el marco del referido instrumento bilateral. Con ello, señor presidente, señores miembros del tribunal, termino estos comentarios y nuestro representante, el doctor Hamilton, y sus colegas entrarán en mayor detalle sobre estos asuntos. Agradezco mucho la atención del tribunal.
Muchas gracias, embajador. Tiene la palabra el doctor Hamilton.
Muchas gracias, embajador, y muchas gracias por el tiempo que usted ha invertido durante largo plazo para preparar sus propios comentarios al respecto. As the ambassador stated, the Republic of Peru is a fiscally responsible sovereign. The former Minister of Economy and Finance and former Ambassador of Peru to the United States, Luis Miguel Castilla, a highly trained and highly credible witness, appeared before this tribunal, and he confirmed that the fiscal management of Peru has been recognized internationally. And let's be clear, Peru is not only an investment grade sovereign, Peru has excellent relations with financial institutions, respects financial institutions, and financial institutions and the international markets respect Peru. Gramercy's years of propaganda campaign have not changed these realities. Gramercy is an outlier. Its conduct is an outlier. Peru remains, as ever, a fiscally responsible sovereign. And it is in that context that Peru established, pursuant to applicable law, a global resolution related to the agrarian reform bonds. It's important to keep in mind that the agrarian reform bonds have a unique history. They relate to expropriation of land undertaken beginning in 1969, over half a century ago. Over half a century ago. And these land bonds are completely different from global bonds. And this has serious implications for what it means to hold a bond, what legal rights are available, what expectations a bondholder might have, and to any resolution related to the bonds. This severe difference between land bonds and contemporary global bonds permeates this case. And it was precisely this unique history that left the land bonds in a state of persistent uncertainty over many years. The Republic of Peru, however, historically resolved this matter. In 2013, the Constitutional Tribunal adopted a resolution that provided for valuation methodology and an administrative procedure, two gaps that had existed over a period of many years. Correspondingly, the Peruvian state, through the Ministry of Economy and Finance, adopted supreme decrees that duly implemented the Constitutional Tribunal ruling based on extensive preparatory materials, hundreds of pages of material before the tribunal showing the careful work that was undertaken to prepare the decrees and develop a bondholder process for the global resolution. It's notable, as we will see, that Gramercy's key expert on this issue admitted that he had never examined relevant underlying documents. That's why the Vice Minister of Treasury, Betty Sotelo, testified before this tribunal that the Ministry of Economy and Finance had duly implemented the ruling of the Constitutional Tribunal, both in terms of law and in terms of procedure. It bears noting that former Vice Minister Sotelo, also the former head of public debt of the Ministry of Finance, has over 40 years of experience in the Ministry of Economy and Finance and has observed firsthand the entire history of these bonds over several decades. In addition, Peru established an effective bondholder process. Peru is not engaged in an exchange offer. It is not engaged in passing laws which are somehow offer or negotiating positions. It is applying the law of established through a ruling of the highest court in Peru, the Constitutional Tribunal. It is a compensation procedure and must be judged as such. It includes authentication, registration, value, and payment steps. Dr. Norbert Wooler is an eminent international expert previously relied upon by international tribunals based on his extensive work with the United Nations Claims Commission. And he concluded before this tribunal that the bondholder process is a fair and effective process for the resolution of the bonds and also for individual bondholders themselves. Finally, the bonds reflect a global resolution. Quantum expert Brent Kaczmarek, deeply experienced in investment treaty matters, concluded that the formula applied by the Ministry of Economy and Finance has no mathematical, economic, or theoretical flaws and provides a reasonable, in fact, favorable outcome for bondholders with coupons that were worthless when the agrarian bank closed. In other words, Peru, pursuant to Peruvian law, duly carried out Peruvian law, created a bondholder procedure, and created a global resolution. The tribunal really need look no further. Peru's case has been supported through multiple witnesses and experts before this tribunal. In addition to the witnesses and experts that I've already mentioned, you also heard from experts in Peruvian law, and we will discuss their comments further as we proceed, as well as the comments of a sovereign debt expert, Dr. Pablo Guidotti, PhD from the University of Chicago, a former Treasury Secretary, deeply familiar with the evolution of sovereign debt issues in Latin America over the past quarter of a century. Next, we will briefly summarize a piece of the puzzle that Gramercy seems to have forgotten in its own closing argument, and that is Gramercy itself. It's time that we open our eyes, come out of the fantastical world that we have seen presented yesterday, and look at the reality of Gramercy, who it is, what has its conduct been, and what does that mean for this proceeding. Gramercy exposed. It literally was the missing piece in Gramercy's own closing argument. Normally, you would hear in an investment arbitration a diligent and respectful presentation with extensive documentation indicating why a company chose to invest based on clear laws or clear contracts based on specific expectations that they might have had about what would happen next. But that is not something Gramercy did in its closing argument because it's not what happened. In fact, the first two words of Gramercy's closing argument were Gramercy's entitlement, because Gramercy's entire case is about a fictional self-entitlement, preferred treatment that no other Peruvians would have, and special treatment that it had no basis to expect from the outset of its arrival to the story of the Peruvian agrarian reform bonds. Keep in mind who Gramercy is. Now, again, Peru has no objection and certainly no ideological objection to financial institutions. It's clear that Peru has good relations with financial institutions and they respect Peru. But Gramercy has conducted itself in a way that is disqualifying to the protection of the treaty and certainly to any compensation. Gramercy is in the business of uncertainty. Its own overview of its activities says they look to buy when there's blood in the street. And as CEO Robert Königsberger said in one of a series of admissions that he made under cross-examination, Gramercy is not in the business of giving certainty or assurances. No, it's not in the business of giving certainty or assurances. It looks for uncertainty to try to exploit it and gain absurd, exorbitant windfalls. The treaty offers no such protections. What is its mission? Gramercy's stated mission is to find ways to monetize distressed debt. Gramercy, in its own statement, seeks to exploit distressed investment opportunities, not certain investment opportunities, distressed investment opportunities. And that's why Gramercy tells those investors in Gramercy, such as American workers, that they may lose all. And Mr. Königsberger repeatedly confirmed under cross-examination that Gramercy assumes that investors may lose all. So Gramercy is coming to this tribunal saying that this tribunal should accept that Gramercy is entitled to all, while everybody else is entitled to nothing. Peru never made any such promises. Now keep in mind that Gramercy, consistent with its approach to doing business, acquired claims amid uncertainty. And you only need to look to the underlying Gramercy due diligence memo. They have a grand total of one. Grand total of one due diligence memo that, as demonstrated in opening argument, is largely cut and paste from another document. And they state in their own memo, the land reform bonds have been in default, in their view, for a period of 18 years. Why would the government seek to reconcile these obligations now? As Mr. Königsberger admitted, from the beginning, there was a lack of certainty. Now, we don't have to just listen to what Mr. Königsberger said at hearing last February, or what their own document said before they began acquiring claims. Let's see what Gramercy said in its own closing argument yesterday. In closing argument, Gramercy's best foot forward, one would think, before this tribunal, Gramercy said the following. Gramercy understood that receiving payment on the bonds would take time and effort. It would take consensus building. Prior slide, please. Thank you. It would take consensus building and even assertion of legal rights. Not only that, Gramercy said, and I quote, at the time of purchase, there was, quote, considerable uncertainty. Considerable uncertainty. And maybe that's why Gramercy went on to say yesterday, what Gramercy invested in is the hope that it would be able to resolve the stagnant land bonds debt. So there was no certainty at the time that Gramercy showed up to this story. Indeed, there was considerable uncertainty, as Gramercy's own counsel declared before this tribunal in its closing argument. Keep in mind that Gramercy acquired bonds through purchase contracts. Now, Gramercy has never provided the physical instruments for 9,656 land bonds that it alleges that it holds. It withheld from this tribunal in Peru for an extended period of time, even scans of those instruments. It knows that they have to be authenticated. It did not bother to put before this tribunal any sort of expert advice verifying and authenticating these old physical documents. They are not authenticated. There is no expert before this tribunal who's done it. They have never submitted to the Ministry of Economy and Finance as other bondholders do. They also indeed did withhold over 20,000 plus pages of purchase contracts. These documents were not all in the possession of the Republic of Peru previously. That was a misstatement yesterday. These purchase contracts also were not even mentioned in the initial pleadings of Gramercy to this tribunal. That's right, members of the tribunal. Gramercy intentionally and knowingly did not disclose to this tribunal that it in fact acquired certain types of limited rights through purchase contracts that it didn't even mention to this tribunal. In addition, and it goes without saying, in addition to other documents that were withheld, Gramercy withheld over time evidence of 10 plus years of internal valuations. And of course, Gramercy admitted, Mr. Königsberger, under cross-examination, that it had bond purchases, it had made bond purchases in 2017 that were also hidden from this tribunal and from the Republic of Peru. The fact that this kind of material evidence was withheld and not presented timely to the tribunal is damning to Gramercy's case. Moreover, inflated valuations, layers upon layers of meringue, as we have discussed before, Mr. President, is really the best way to understand the exorbitant amounts that Gramercy seeks. The key figures you need to know, members of the tribunal, are that Gramercy, having hidden its purchase contracts, ultimately admitted that it actually spent $33 million to acquire bonds. Not only that, it used the money of others. Gramercy didn't spend its own $33 million. It used the money of others. And these bonds are held for other beneficial owners, which includes many US citizens, but it includes non-US citizens, and it appears may include Peruvians. The other thing Gramercy has admitted is that it could have obtained $34 million through the duly established bondholder procedure. Those are the two numbers you most need to know, members of the tribunal. Everything else is fabricated, invented, meringue, dislocated from theories of compensation under a treaty. And by the way, it's also telling Gramercy valuations. Gramercy uses management fees to make money during the life that it is pursuing a resolution on claims. So Gramercy was making money all along based on a percentage of assets under management, and Gramercy set the valuation itself. It created its own valuation, generating its own management fee. And I'd love to talk about it. And again, we apologize to the United States government, but Gramercy insists that while it can degrade Peru in public, it wants to keep secret various information about Gramercy. Finally, what has its strategy been over the course of this dispute? Its strategy has been to weaponize this dispute, This is not just aggravation. It is not an annoyance. It is abuse. It is abuse, and Gramercy is enrolling constant, and as we sit here today, violation of the express instructions of this tribunal and repeated orders of this tribunal over the past 2.5 years, that it should stop, that it should respect this treaty proceeding. And Gramercy has hired countless lobbyists. It has used experts that it pays but doesn't reveal publicly what they've done. It uses propaganda that sets out disinformation and falsehoods about the Republic of Peru. And as Gramercy itself said, we're going to create grist for the media mill. Well, you tried, Gramercy, but Peru will not bow to bullies and extortionists. This is wrong conduct. This is not the kind of conduct that can be permissible in the context of a treaty proceeding. And let me give you just one example. Gramercy intentionally tried to interfere with bilateral relations related to the OECD and Peru's process of entry into the OECD, and repeatedly threatened that it was going to stop Peru's entrance to the OECD. Now, how is that in the interest of the development of Peru or of the relations between Peru and the United States as contemplated by the treaty? It's not. And that's why the reality is that Gramercy has been on a campaign of deception. Gramercy uses this kind of absurd propaganda. A billboard parked in front of the United States Congress stating, "Peru defaults, American workers pay the bill." Well, if Gramercy has a problem with American workers because of the way it's managed its clients' money, that's a problem between Gramercy and American workers. Peru never marketed 50-year-old agrarian reform bonds on international markets. There's absolutely no connection between this and contemporary bonds. And most telling is that Mr. Konigsberger admitted that at or around the time of this billboard, Gramercy was purchasing additional land bonds. Is that correct? And he admitted somewhere in that time period, yes. And after an order of the tribunal, we learned and discovered that in fact, Gramercy was continuing to purchase bonds during that time period. It was continuing to purchase bonds, but it certainly was not telling that to the United States Congress, the State Department, or the executive branch of the United States government. Now, we will now go into a discussion of the facts, jurisdiction, merits, and compensation. And our aim, Mr. President, is to go through the facts and then take a break. With respect to the facts, we're going to discuss the following issues. First of all, the uncertainty that predated Gramercy's acquisitions of land bonds. Second, the acquisition of land bonds and persistent uncertainty thereafter. Third, Peru's legal resolution related to the agrarian reform bonds. Fourth, the bondholder process. And finally, a few observations on the aftermath.
Mr. Hamilton, we've lost you.
Yes. You are back.
For you, sirs, here for you. Regarding uncertainty, remember that the bonds have unique origins and characteristics. This was a domestic dispute marked by legal and value uncertainty. The unique origins of the agrarian reform bonds are clear to this tribunal. They date back to 1969, and after a period of inflation and currency changes, there was significant uncertainty and the bonds effectively became worthless. In 2001, in a much discussed court decision, the court rejects the concept of nominal payment, but it did not resolve all the pieces of the puzzle to determine what would happen to the Peruvian land bonds. Specifically, as former Minister Castilla and former Vice Minister Sotelo explained, the agrarian debt is a unique historical chapter of Peruvian history. We heard a lot yesterday from our counterparts about the obligation of this tribunal to render justice related to something that happened in 1969, to try to use as pawns Peruvian citizens who were affected half a century ago by the agrarian reform process. That is not why this tribunal is here. That is simply paper that Gramercy is putting over itself because it itself is such an unsympathetic claimant. Let's be clear. This is an old domestic dispute that Gramercy chose to interfere with, to become an intermeddler with these circumstances. The unique characteristics between these two types of bonds are really dispositive to many of the issues before the tribunal. And we discussed the difference in old agrarian bonds and contemporary bonds in great detail at the hearing, discussed with Mr. Konigsberger as well. And Mr. Konigsberger made clear, and Gramercy's own documents made clear, that its preference is to acquire contemporary bonds that have all of the contemporary types of protections, clarity, promises, certainty that accompany those kinds of instruments. That is not what Gramercy did in this instance. For whatever reason, it chose to enter a situation of great uncertainty. And these differences between the two types of bonds before you, members of the tribunal, permeate many of the issues of this case. Now, remember that by the 1990s, the bonds became worthless. Sebastian Edwards acknowledged they became virtually worthless. And that's why both Peru's quantum experts and Professor Guidotti emphasized that Peru never defaulted. Literally, the bonds became worthless after extreme hyperinflation in a very difficult period of time and multiple changes in currency. This is the seed of the deception of Gramercy to repeatedly tell the United States government that Peru was in default, something that in fact bondholders, financial institutions, and rating agencies have all rejected. So then we come to the decision of 2001. The 2001 sentence was limited. It was a limited ruling that provided only that nominal payment was unconstitutional. The operative language in this sentence is one small paragraph depicted before you on slide 25, members of the tribunal. It was uncertain with respect to valuation method, no rule mandating CPI, no rule on reference date, no rule on interest, and it was uncertain on payment procedure. And as we'll see later, it's exactly these two elements, valuation method and payment procedure, that were ultimately addressed in the 2013 Constitutional Tribunal decision. I now invite Mr. Gijon to share additional observations on the uncertainty of Peruvian law pursuant to the 2001 sentence.
Thank you, Dr. Hamilton. Happy to give the floor to Dr. Gijon. On behalf of the court reporters, if Dr. Gijon could speak slightly slower, I think it would be appreciated. Dr. Gijon, you have the floor.
Mr. President, excuse me. Sorry, Mr. President, the court reporters and interpreters are also asking if they could be sent the speaking point.
That is important, yes, because it makes their life so much easier and the quality of the interpretation so much higher. So that would be highly appreciated.
Thank you.
Thank you, Mr. President, members of the tribunal. Good morning, good afternoon. Thank you for this opportunity to speak on what Gramercy yesterday described as the central issue of this case. This goes to the very heart of what they call, quote, Gramercy's entitlement. And as Dr. Hamilton mentioned, this all arises from the 2001 sentence, which is an extremely limited decision by the Constitutional Tribunal. It is 4 pages in its entirety. The operative part relevant to this being paragraph 2. Paragraph 2, which merely says that Article 2 of Law 26597 from 1996 is unconstitutional insofar as paying nominal value for bonds did not take into account the effects of time, ajeno a las circunstancias de tiempo. This one paragraph is the basis for Gramercy's argument that there was a clear legal rule. However, it is obvious on its face that this is not the case. And aside from the rhetoric that Gramercy has deployed yesterday and throughout this proceeding, this is not borne out by the evidence. Now, this is a very important rule because it was the first time that it was established that the bonds should be paid at current value. And it's not in dispute that the bonds should be paid at current value. However, there is a dispute as to what current value meant at that moment. And the idea that there was certainty as to how the current value principle was to be applied is absurd. And again, not borne out by any evidence in the record. Contrary to what Gramercy argued yesterday, there had been no cases at this time or previously saying that the bonds had to be updated at all, much less that they had to be updated in the way that Gramercy wants and says is the clear legal rule coming out of this case. Next slide, please. So on the first point, there is clear uncertainty as to the valuation method. And both parties' experts agree that the 2001 sentence does not, and I repeat, it does not make any reference to the CPI method. You can go through the entire sentence, shouldn't take too long. The only operative part is that one paragraph. There is no reference to CPI. And as Dr. Hunskoff, an expert in Peruvian law, explained, you cannot read a reference to the circumstances of time, to the current value principle, as meaning CPI. CPI and the current value principle are not synonymous. Next slide. Now, Gramercy, because it has to accept that the 2001 sentence was silent as to the valuation method, has argued that CPI, that its preferred valuation method, is implicitly required by current value. Unfortunately, this is simply not the case for Gramercy, and Gramercy does not and cannot support that. It tries to do so with experts. And yesterday, we saw Gramercy referring to the report of Delia Reboredo, which was quite surprising because that report was Gramercy's first attempt to address these issues in this case. However, Delia Reboredo was withdrawn as an expert. She was absent during the hearing. She was unavailable for cross-examination. And it is critical that she was unavailable for cross-examination because after she had submitted her report, Dr. Hunskoff identified numerous flaws in her report. And it was only after that report had been demolished by Dr. Hunskoff that she withdrew. It's also significant she was unavailable for cross-examination because, as was mentioned at the beginning of the hearing in February, Dr. Reboredo has potential conflicts of interest that have been raised in the past and on which we were never able to cross-examine her. Nor can Gramercy depend on Dr. Castillo Freire for this point. Now, Dr. Castillo has made it very clear that he believes that CPI should apply as a general rule. And again, yesterday on Gramercy's slides, you saw that as a general rule, the current value principle requires the use of CPI. However, on cross-examination, we asked Dr. Castillo whether CPI applies as a general rule, that is, by default. And he said By default, no, no, no. Next slide. Now, it is also evident from contemporaneous court cases that you don't need to take the word of the experts. Courts in Peru at or around the time of the 2001 sentence were applying the current value principle to other types of debt. Now, yesterday, Gramercy tried to put me on the spot by putting an exchange between the president and myself during the prior hearing, where the president asked whether these cases had to do with the bonds. And the answer is no. But why is the answer no? Because, as I mentioned, there were no cases prior to the 2001 sentence, and there are certainly none in the record, where people were updating the bonds with dollarization or with any other method. They just aren't there. And we asked Dr. Castillo if he knew of any cases in the 50 years since the bonds had been issued where they had been updated prior to the 2001 sentence, and he said he did not. So the other thing that Gramercy has to rely on, and they argue, is that, well, okay, maybe CPI is not the default for all applications of the current value principle, but it's going to be the default for updating sums of money. Now, this is a really sneaky argument because you're going to recognize that in this context, they describe the bonds as a debt for a sum of money, whereas in others, they call it a debt for compensation for expropriation. And why is it sneaky? Well, because in Peru, debts for sums of money are not, as a general rule, subject to the current value principle. This is something that is not in question. All the experts have agreed, including Dr. Castillo, who said as much in his direct testimony. However, just so that there is no doubt in the tribunal's mind, if you look at the cases that are in the record, you will find that dollarization was used both to update sums of money and compensations of various sort. Next slide. And this is just to say that Dr. Castillo acknowledged that dollarization was being used as a method of applying the current value principle. Next slide. Another uncertainty in the 2001 sentence refers to the reference date. That is, when you are going to calculate or update the value of the bonds, what date do you start at? Dr. Hunskoff points out quite correctly that nothing in the 2001 sentence tells you where you should start calculating. And that left the door open to different dates being used. You could use the expropriation date, the placement date, the date of the last clipped coupon, the date the last payment was made by the agrarian bank, the day the bank was liquidated, the day that a purchaser of bonds acquired those bonds, etc. None of these are necessarily wrong or right coming out of the 2001 sentence. They were all potential reference dates. The point is there was uncertainty. Next slide. Now, Gramercy is a little flippant on this point. They say, and yesterday we heard them just dismiss using other dates. They said using any date other than the date of the origin of the debt is like valuing from the date of a solar eclipse. Well, that may sound pretty, but it's absolutely nonsensical. Absolutely, it can make sense. If you are trying to value a debt, why not update it from the day that that debt was going to be paid? So what does Gramercy do? They have a different argument. They say that the debt was not born on the day it was supposed to be paid. They say you have to look at the date of the origin of the original obligation. And here they're not talking about the bonds. What they are talking about is the debt for the original expropriation of land during the agrarian reform. And they say that that obligation has to have been the date of expropriation. Why do they say that? They say it's required by the Peruvian Constitution. And yesterday, again, they point to Article 70 of the Peruvian Constitution, which says that for expropriations, payment must be made in cash on the date of the expropriation. Now, that is quite correct for expropriations under the current Constitution. But it is astounding that they should continue to make this argument, because Peru has shown time and time again that that Constitution and that provision was not applicable when the bonds were issued. A fact that Dr. Castillo acknowledged on cross-examination. We asked him at the time of the expropriation, could the state pay, was the state required to pay with prior indemnization, or could it pay with overtime and in bonds? And he said, yes, of course, that was the point of the constitutional amendment of 1964. And in fact, at the time of the agrarian reform, the Constitution said that expropriations undertaken for the point of agrarian reform could be paid over time, not on the date of. Next slide, please. I'm going to go quickly over interest. As Dr. Hunskoff has confirmed, again, there is nothing in the 2001 sentence to refer to what type of interest was required to update the bonds. And Dr. Castillo also said that this is Gramercy's only expert, mind you, that he had not addressed this issue in his report, that he'd not gone into it a hondo, but that interests, there's something different from current value. So even if the 2001 sentence is read to be about current value, it is not implicit that it should be read to say anything in particular about interest. That's something different. Next slide. You don't have to take our word for it or Gramercy's word for it. Look at how the 2001 decision was interpreted over time. In 2004, a commission that had been put together for the express purpose of interpreting the 2001 sentence concluded that there was uncertainty. This commission was made up of representatives both of the public sector as well as by bondholders. And they concluded that no valuation methodology was required by law, that the laws did not require any particular methodology. And when they did their attempts to quantify what a potential valuation could look like, they used 3 different valuation methods. Not only CPI, not only the method that Gramercy says was the clear legal rule. It wasn't. There was a dollarization method, a CPI method, and an adjusted CPI method, all of which resulted in very different calculations. Next slide. Now, what else happened in 2004? There was another constitutional tribunal decision. Gramercy has consistently misrepresented the significance of this decision. Contrary to what Gramercy says, the relevance of this decision does not lie in the fact that it made dollarization an optional method for determining current value. What this decision says is that dollarization is constitutional and consistent with current value. And the Constitutional Tribunal said fundamentally, the difference between the emergency decree that mandated dollarization and the 1996 law at issue in the 2001 sentence was that dollarization was consistent with current value. It did not ignore the effects of time. Next slide. And what happened the following year? 2005, another commission, this time in the legislature, once again looked back and they adopted the recommendations of the 2004 report, or recognized them and reaffirmed the conclusion that the law did not limit or restrict the factors or indices required to update the bonds. And again, they used these different methodologies, including the adjusted CPI. Now, Dr. Castillo, on cross-examination, admitted that he did not know about the 2004 report until after he had finished his expert report in this case. And he said, well, it's this CPI, adjusted CPI, it's cheeky. I don't know what that means. He can dismiss it all he wants, but the point is that at the time, various commissions of the Peruvian government, including a commission that included bondholders, included and recognized this uncertainty. Next. Again, we see how this was applied in the courts. All I want to say here is you can see for yourself, different types of indices were being used, different reference dates were being used, different interest rates were being used. Not one of these is what Gramercy says is the default clear rule that should have come out of 2001. Next. Dr. Castillo agrees. He said he's read these cases and he's read other cases, which apparently are not in the record, but he's read others that came out in even different ways. And he acknowledged that there are different types of CPI, not just one type of CPI. And contrary to what Gramercy said yesterday, it's not that CPI is CPI is CPI. He said, I've always had this doubt about whether we should use the CPI of the place where the bonds were issued. Well, he may have that doubt. Gramercy apparently never did, because they never did this. They've used one type of CPI, and they have said only that one type of CPI could ever be used. Next slide. And finally, if further proof were needed, you can just look at how the legislature of Peru tried for many years to resolve the uncertainty. There were many draft bills, all of them failed. None of them included exactly what Gramercy says is the default rule. Next. So to conclude, what we see is that there continued to be uncertainty as of 2001, and going forward through 2006, there were failed attempts at legislation, no consensus in the court, and there is no basis in Peruvian law for assuming that Gramercy's entitlement is in fact obvious or required by law. Thank you, members of the tribunal.
Thank you, Dr. Gijon. Who is taking over from you now?
Have no fear, Mr. President.
Mr. Hamilton.
I'm back.
Welcome back.
Thank you. Thank you very much, Dr. Gijon. How could there be any serious doubt left that the conditions of the agrarian reform bonds were uncertain as of 2006, when Gramercy began to acquire these instruments? The timeline, the evidence, the law, the experts, and grammar itself all make it quite clear. And keep in mind that this was not only a period of legal uncertainty, but as quantum expert Brent Kaczmarek emphasizes, it was a time of value uncertainty. The decision was unclear as an economic matter. It is ambiguous, open to interpretation, and not possible to make a calculation. Ergo, value uncertainty. No doubt then why Mr. Königsberger admitted there was a lack of uncertainty. There was a lack of certainty, or as Gramercy itself stated yesterday, considerable uncertainty. Now that was the status when Gramercy chose to get involved with the agrarian reform bonds. And next I'm going to speak about something that Gramercy totally admitted from its own presentation, which was how Gramercy entered the picture and acquired agrarian reform bonds. Please buckle up because we're going to go quite quickly through this segment as we get rolling. Now, we've mentioned that Gramercy was, in the words of Bloomberg, a lone hedge fund. Other people were not rushing to get involved in agrarian reform bonds. There were not funds rushing to Peru. Peru didn't invite anybody to come and acquire agrarian reform bonds, market them in the international markets. There was not some great certainty at the time. Otherwise, why would people be selling their bonds? You only need to look at Gramercy's own due diligence memo from January of 2006. It's in the record at CE 114. And just to briefly summarize, it refers to bonds that were in arrears, in Gramercy's view, in default. It emphasizes complexity, long periods of time for legal proceeding, long periods of time for government to make a payment. They hope for some form of resolution. They emphasize the importance of physical authentication of bonds. They focused on draft legislation, discrepancies, differences in government approaches, a proposal to use CPI, multiple alternative valuation scenarios, and the possibility of acquiring bonds at a discount off of an estimated claim. Uncertainty. That's Gramercy's own words. Contemporaneously, it's toasted. There's another thing that's important about the outset of Gramercy's acquisition of bonds, which was carefully timed to align with the signing of the US-Peru Treaty. If you look at the evidence, and this is outlined in Peru's prior briefs with timelines, the treaty was signed in April of 2006, and within days, claimant was established. And Gramercy then proceeded to acquire the bonds. That's because Gramercy knew from the beginning that it was going to have to try to resolve claims that were pre-existing and part of a pre-existing dispute. The uncertainty was confirmed even by a report signed by Vice Minister Sotelo, then a functionary in the MEF, confirming that it was pending the establishment of a legal framework. And Mr. Königsberg acknowledged that Gramercy knew that that was the position of the ministry. So what did Gramercy do in the face of all of this uncertainty? It proceeded just the same. It acquired bonds that it never authenticated, and those bonds were withheld from this tribunal for a long period of time. Gramercy not only didn't authenticate the bonds, it used client funds. The claimants only have a de minimis interest, and the beneficial owners do not all have U.S. nationality. Some may even be Peruvian, as indicated through cross-examination. I direct you to the crosses of Mr. Lanava, Mr. Königsberger, and Mr. Janou. And what did Gramercy actually acquire? It entered purchase contracts showing that there was use of Gramercy funds obtained through Gramercy clients, $33 million. And Mr. Janou admitted that Gramercy paid $33 million. So they asked for they paid $33 million at the time, and they paid for derecho expectaticio. That is what they obtained. And Mr. Honskopf explains that derecho expectaticio means a gamble, a remote possibility. This is the opposite of a scenario where a company goes to a host state enters into, let's say, a concession agreement in a clear legal framework with certainty based on clear contractual provisions that set out its rights and expectations. This was the opposite. And as you look forward, Gramercy over time continually was trying to change the law and supporting efforts and behind efforts to try to change Peruvian law. And it also quickly resorted to treaty threats after the treaty entered into force, including a statement in 2010 referring to the free trade agreement between Peru and the United States. And that is in the record before the tribunal. Now, the key thing about all of these efforts to change the law, if everything was certain, why are you trying to change the law? They knew from the beginning they were going to try to change the law. Repeatedly, they sought to change the law to try to inflate what they thought they could receive. Now, unfortunately, we can't show the public and the United States government all of the evidence, the damning evidence of Gramercy related to these efforts to change the law. But one thing is quite clear. All these legislative efforts failed. 2006, failed. 2008, failed. Again in 2008, failed. 2011, failed. Multiple efforts to change laws to try to create certainty where there was none. But as we all know, to change the law, you're going to need congressional approval, and they didn't have the votes. Meanwhile, limited resort to local proceedings. As the tribunal asked yesterday, if it was so clear that you could go to local courts and magically receive $840 million on these instruments that you paid $33 million for, why didn't you do it? Because it wasn't certain, because they wouldn't have obtained that. And it's very clear that they became parties to some legal proceedings, but obviously chose not to proceed locally. That's because there was no certainty with the situation. The uncertainty persisted. You can look to contemporaneous documents of Minister Castilla, even in his era as Vice Minister of Finance. It's in the record, no legal framework. And again, when Gramercy tried a backdoor approach to the minister in 2012 on the side of a meeting with other financial institution, the response was the same. There's no legal framework. And keep in mind that all this time, Gramercy was making money anyway, because Gramercy was making money on management fees all along the way. And as Mr. Konigsberger admitted, Gramercy's own calculation of the valuation of the bonds, which it keeps secret from the United States government, determines Gramercy's management fee. And this was performance-based compensation as they themselves valued the bonds at a time of rolling uncertainty. Gramercy was making money as it went. Now, of course, as we'll hear later, Gramercy has never put before this tribunal any breakdown of what actually happened to the claimants before this tribunal that were making money through management fees, how they were specifically impacted. It ignores that entire piece of the puzzle. And that's because it is not favorable to Gramercy. Bottom line, Gramercy acquired bonds at the time of the great uncertainty. It acquired bonds with limited rights through purchase contracts, and it repeatedly sought to change the law and bring certainty to no avail. Changes in law to which it had no right and no reasonable expectation. That's why it's so critical that in 2013, the Constitutional Tribunal of Peru resolved this matter. It recognized the prior uncertainty, established certainty, and remains valid law of Peru. There can be no doubt that the Constitutional Court resolution identified precisely the lacuna in the 2001 decision. It referred to the lack of valuation criteria and the lack of clarity on an administrative procedure. There's simply no doubt about this. It's as plain as day. And that's why the 2013 resolution was an historic resolution. It established a valuation method. Now we see clarity, dollarization, how do you update it, how do you use interest, and it mandated a payment procedure. Mr. Gijon, very briefly, we'll touch on the legal circumstances related to the resolution. Thank you.
Dr. Gijon.
Thank you. Very briefly, unlike the 2001 sentence, the 2013 resolution is much more in-depth. Next slide, please. First, the Constitutional Tribunal did address various methodologies, several methodologies, in fact, and it once again said these are all potential methodologies. It examined the possibility of CPI and it examined dollarization. Next slide. And having done so, it determined that dollarization should be applied to update the bonds. This was critical. This was the first time that it became Peruvian law that there was a fixed method for determining the value under the current value principle. Next slide. In addition, the court mandated a payment process. And this was also very important because this allowed and in fact required the Ministry of Economy and Finance to establish an administrative procedure to be able to pay the bonds. And it established exactly what the types of regulations had to be, the steps that had to be gone through in order to reach payment, including authentication, registration, valuation, and determination of payment. And this was confirmed by both Peru's experts, Dr. Hunskov and Dr. Garcia Godos. Next slide. And I want to just end noting that the court recognized that there were challenges and discussion of the 2013 decision going on in public. So a month after the decision, they met, they debated, all of the magistrates debated the situation. And as the record of their meeting indicates, they unanimously agreed this case is closed. Thank you. Dr. Hamilton.
Señor Hamilton, tiene la palabra.
The 2013 court resolution was the cornerstone of the global resolution.
Excuse me, Mr. Hamilton, I don't hear you at all, sir.
For your information, I think the rest of us do, or at least some of us do.
I do too. Let's try again, Mr. Hamilton.
Sure. If there was any doubt, the 2013 tribunal ruling was the cornerstone of the global resolution of the agrarian reform debt.
Does this work with the court report? Yes.
It's much louder now, thank you.
Thank you.
Thank you. Mr. Hamilton.
Just very briefly, we're going to touch on Gramercy's unproven attacks. Gramercy strangely attacks the resolution that finally brought the legal certainty that they had been craving. Their issue is very simple. Gramercy just wants more. That's all that Gramercy ever wants, is simply more. This court resolution clearly establishes and resolves the legal uncertainty and set the stage for a bondholder process that has functioned as a global resolution of this problem. Keep in mind that Gramercy, despite a lot of mudslinging, has never delivered any meaningful evidence to undermine the origins or the validity of this court decision. Minister Castilla expressly rejected allegations of interference. The magistrates denied interference, and a criminal prosecutor confirmed the irrelevance of a proceeding related to the liquid paper issue about formalities of signature processes. Very briefly, given the time that we have, I want to note that Gramercy did not go through in its closing argument, as in its opening argument, its fantastical timeline based on basically press statements, principally trying to string together some sort of conspiracy theory about the origins of the tribunal ruling. And in fact, Gramercy misuses the transcript of Minister Castilla. And let's just be very clear what he said. And I'll read briefly. Minister Castilla said, "I reject such statements, and I reject those statements or assertions, period. Punto final." Minister Castilla is a highly internationally respected public servant, and his testimony was clear and credible. And you can look specifically at the exchanges between the president of the tribunal and Minister Castilla regarding the reality that a minister in Peru receives diverse officials in the normal course. And keep in mind what Gramercy acknowledged under cross-examination, and what the facts show is that it was Gramercy that was repeatedly visiting the court. You can look to R467, the Registry of Visits to the Constitutional Tribunal, and you see over and over and over again visits by representatives of Gramercy, and an internal email to Mr. Königsberger explained, "We are discussing issues with the president of the tribunal." And under cross-examination, Mr. Königsberger, while clearly uncomfortable, made it clear that Mr. Seone, for example, was both their counsel and counsel to other bondholders. And they were actively advocating before the court. And as Mr. Königsberger acknowledged, it's a bit different than in the United States. You invest abroad, sometimes things are a little bit different. None of this reflects any sort of conspiracy theory. And on top of that, the congressional record. Gramercy made a big deal in this case about a congressional investigation that was going to uncover things related to this court decision. It is resorted simply to ignoring the outcome of that investigation, and again, misusing the transcript. Members of the tribunal, I encourage you to look at slide 72 and the actual testimony of the justices who repeatedly said that they rejected and did not suffer pressure or interference. They specifically say that they reject, that is absolutamente falso, absolutely false, that they were improperly interfered with. That is what the record says. And that's why the Congress rejected those accusations. The whiteout has been shown to be a red herring as well. Maybe great for propaganda campaigns, but not so good as evidence. I again encourage you to look at the record. Finally, a criminal process related to formalities of an administrative person in the court found no relevance or impact on the validity of the court decision. Keep in mind, members of the tribunal, that the government was not thrilled and did not embrace this resolution. In fact, it presented a recurso afterwards. So if there was this magical intervention, why were they so unhappy afterwards? The bottom line is that there was a recurso. The court and the justices confirmed their ruling, and the government went ahead and duly implemented the ruling. End of story. Bondholder process, briefly. The Ministry of Economy complied with the court mandate. As Minister Castilla and Vice Minister Sotelo explained, they duly and in good faith carried out the instructions of the Constitutional Tribunal. They did so through the development of decrees. First, there were decrees in 2014 that established the bondholder process. They got the process moving, and they anticipated further Supreme decrees. Subsequently, they refined the valuation methodology precisely to to clarify and confirm the valuation before any methodology was ever applied to any bondholder. And they established the payment option methodology. Finally, soon after that, they adopted a bill that is, it's called a TUA. It's a Texto Único Ordenado. And this is a very common instrument. It's been in other cases that members of the tribunal have been a part of related to the Republic of Peru. This is basically a consolidated text that leaves clarity published in El Peruano and in the public record, exactly the final steps of the process. Now, one looks in cases to see, was there a diligent, rational process? Yes. Did the ministry comply with the court ruling? Yes. There are over 400 pages of material in the record before the tribunal related to internal studies and processes that led to the development of each decree implementing the ruling of the court. And you can see, as an example, that they include reports of a local financial expert and also, for additional security, an international financial expert as well. This is not the kind of scenario where a government slaps something together and the tribunal somehow needs to go in and second guess everything it did. This is a highly regarded Ministry of Economy and Finance, very well regarded around the world, very well respected by international financial institutions, rating agencies in the international markets. They carried out the court order. They duly implemented relevant decrees. They duly developed all aspects of the process. And these decrees, let's be clear, they set out statements of reasons. Pre-publication was unnecessary. And Gramercy, in its closing argument, again, is just trying to misrepresent the records regarding the reasonableness of these decrees. The reality is that the kinds of attacks that Gramercy tried to make on the decrees at the hearing previously simply do not hold water. And perhaps most telling was that Gramercy's expert brought in our view, in violation of due process, late in the proceeding to attack the decrees, did not even review the complete set of Supreme Decree records. And I want to read in Spanish to be clear. Gramercy's expert brought in to attack the Supreme Decrees. This is what he said with respect to the deep record of documents showing how the MEF carefully prepared these decrees. And I'll read in Spanish. Para ser honesto, hay documentos que yo no había visto nunca. Entonces, no estoy seguro si eran parte o no de este expediente. Pero lo que he recibido para el análisis no incluye todos esos documentos. No recuerdo todas esas cifras, todos esos documentos. No recuerdo el cuadro al final. No recuerdo todas esas cifras, todos esos documentos. Their own expert crumbled. And this someone who unfortunately has given conflicting opinions in other cases and in fact is claimant's counsel against Peru in other treaty proceedings. The bondholder process accordingly was established. This is a compensation procedure. It is a compensation procedure. As everybody knew from the beginning, this is not a contemporary bond procedure. One of the interesting things that I noticed yesterday is that Gramercy describes laws as offers and decrees as negotiations. Not in this world. These laws are not offers to Gramercy. They're laws, regulations, decrees adopted to comply with applicable law, with instruments subject to applicable law, as everybody's known since 1969. And so this process, authentication, registration, actualization, and payment is a perfectly normal compensation procedure where a government is taking physical instruments that must be authenticated because you cannot have gross incidence or risk of fraud with respect to payments by the state. That's why they have a procedure. They have duties as public officials. And this procedure shows that the MEF has been paying bondholders going through this process. It is in the hands of bondholders to present their papers and participate. This is a thorough and rigorous process. We've demonstrated on the screen a single case record showing the amount of documentation prepared in order to process a bondholder. It's simple. It's an old process that a special procedure had to be devised for. If you wanted contemporary global bonds, go spend your resources on contemporary global bonds that have a different way of organizing files. Nobody knows, Mr. President, how many outstanding bonds there are. That's not the way this was handled. We all think in terms of the way things are done today. That's not the way that things were done in 1969. Payments were made for land. Payments were made in paper. There is no registry. There is no clarity on the total bonds outstanding. The numbers we hear from Gramercy are invented by Gramercy for its own purposes. And finally, the bondholder process, yes, it was transparent. Information available, a clear website, explanation of valuation, detailed instructions, and answers to questions available to bondholders. All of these reasons are why Dr. Wooler, an esteemed international expert, concluded that the process is transparent, it's fair, it's effective, it's a functioning compensation procedure. Final comment on bondholder procedure. Gramercy undermined the global resolution. Gramercy, from the beginning, with its deception and campaign of propaganda, has tried to undermine the functioning of the bondholder procedure. It's done this intentionally to interfere with and reduce participation rates for its own aims to try to enhance its treaty case. It has attacked the bondholder procedure using extreme propaganda, and it's wrong. They have not been a key to a solution. Gramercy has specifically been the obstacle to a global resolution of this problem, and this cannot stand. This cannot stand. An esteemed Ministry of Finance duly implementing the ruling of the highest court in the land, carrying out hundreds of pages of background material to prepare decrees, to establish a compensation procedure, given the seal of approval by a leading international expert. It should not be attacked and undermined so that an entity that acquired distressed claims can try to maximize its chance for success in claims. And keep in mind, some of the sellers to Gramercy would have done better with the MEF. A final comment about the bondholder process. And I refer you to R197 as part of extensive discussion and exchanges between the parties. And in this letter, Peru summarized the state of affairs in 2017 as follows. Legal framework. Peru has taken note of Gramercy's observation that the Supreme Decree can be a feasible framework for resolution. Check. Verification. Peru has taken note of Gramercy's acceptance that Peru needs to verify the legitimacy of agrarian reform bonds. Check. Form of payment. Peru has taken note that Gramercy has confirmed its willingness to accept a non-cash payment in the form of new bonds, which is precisely what the bondholder procedure offers. Check. On each of these core elements of the bondholder procedure, Gramercy confirmed that they were sufficient. This came out of meetings that were not subject to confidentiality protections. They were never rebutted in any way whatsoever. The real issue for Gramercy was and has always been valuation, because Gramercy wants more, and they'll always want more. Briefly as to aftermath. Gramercy has engaged in misconduct in this arbitration, repeated procedural violations, repeated aggravation, and direct efforts to interfere with the attorney-client relationship, including using a shell company and lobbyist to interfere with the attorney-client relationship between the U.S. government. It's wrong. Gramercy has withheld evidence. I discussed it in the opening. It stands as a serious problem to the proceeding. Gramercy never revealed its secret acquisition of bonds. Gramercy sliced like a razor various representations it made to this tribunal. We made our final land bond purchase in 2008. There were multiple statements previously and throughout the document production process that were clearly designed and crafted to try to hide their 2017 acquisition. Only on cross-examination did Gramercy finally admit the truth that it was still buying bonds while it was attacking Peru in public. And it bought new bonds, 223 bonds, $15 million of its clients' money, none of its own, valued the bonds at a very high amount, sold interest in these bonds to third parties. And by the way, Gramercy admitted that in 2017, it was a good idea to acquire land bonds. This is after the court ruling, after the Supreme decrees, and during the bondholder procedure stage. Their conduct is at odds with their exaggerated arguments and propaganda. And by the way, the secret purchase agreement that we uncovered only after the tribunal ordered Gramercy to do so makes it clear they're teeing up more. Because you members of the tribunal, I'm sorry to say, are pawns in Gramercy's campaign. They have already lined up more bonds, probably for some other type of treaty claim, which they would not answer at the hearing, but you can see it reflected expressly in the document itself. But keep in mind, all of this happened during a period of aggravation, a propaganda campaign, attacks on sovereign relations, deception of the non-disputing party, where inaccurate information is given to the non-disputing party. And meanwhile, even in this proceeding, the non-disputing party does not get full access to information. Desperate lobbying, which actually intensified in 2020, despite the request of the president and repeated orders of the tribunal. That's the reality. It's not just aggravation, it's treaty abuse. We will now take a break, Mr. President.
Thank you, Mr. Hamilton. Let us get a time check from the secretary so you know where you stand.
Thank you, Mr. President. The respondent has 1 hour and 3 minutes left.
1 hour and 3 minutes left. Very good. So it is now 16:36 in Europe. Shall we say that we come back in 15 minutes? That would be 40, 36, 46, 51, that's 55, 16:55, we are back. Would that be okay, Mr. Hamilton?
5 minutes before the hour, Mr. President. Sounds good.
Sounds good?
Thank you,
Sounds good
Mr.
to
President.
everyone? Very good. Then we come back 5 minutes to the hour. Thank you.
Thank you very much. Hola a todos.
¿Qué tal? Muy buenos días, doctor Hamilton.
Señor presidente, tenemos empanadas aquí y lomo atado también.
Pues encantado, ¿por qué no lo comparte? Un
Estamos
despacho.
los coffee breaks y la oportunidad de conversar como humanos.
Pues es una pena, un despacho bien organizado debería haber tenido un sistema de catering para que a todos los miembros del tribunal y a los compañeros de la otra parte les llegase en la hora del coffee break un pequeño regalo de White Case con lo mismo que están tomando ustedes.
Tomamos nota.
I don't know if I don't know if we have the rest of the teams with us, at least not on the screen. But I'm sure that Mr. Friedman and his colleagues would have appreciated
Some empanadas, why
the
not?
nice gesture from White and Case.
We would be glad to break bread and share empanadas with all together.
We are all. Oh, this is definitely off the record, Dawn. Thank you very much. But definitely, I mean,
Yes.
by the way, good morning to you, Dawn.
Good morning, sir.
Dawn.
Very good. So I think we can now start. Let me ask first our secretary if all the different participants in the hearing are now present.
Yes, they are present.
Very good. So we resume, and now on the record, and now we resume the hearing, and I give the floor back to the Republic of Peru.
Thank you, Mr. President. I invite Ms. Miniker to please, there we go. Ms. Miniker is going to address jurisdiction and merits together with our colleague, Jonathan Ulrich. Thank you.
Very good. Ms. Miniker, you have the floor.
Thank you, but okay, there it is. I couldn't see all members of the tribunal, but I do now. Thank you. All right, so good morning, good afternoon, members of the tribunal. And as Mr. Hamilton said, I'm going to begin by discussing some of our jurisdictional objections, and in that regard, begin with our temporal non-retroactivity objection. Now, yesterday, Gramercy did not even discuss this objection and suggested wrongly that we may have even abandoned it, but that is far from the case. We very much maintain this objection, and in fact, it's quite central. It goes to really the heart of the problems with Gramercy's case and the tribunal's lack of jurisdiction. And as you know, the treaty does not retroactively apply to acts or facts that predate its entry into force. That's clear from the treaty's language and is a principle of customary international law. Now, ipso facto, the treaty also cannot retroactively apply to disputes that predate its entry into force. If it does not even apply to an act, it clearly doesn't apply to a dispute that predates the treaty's entry into force. And this is the fatal flaw with Gramercy's claims, which is that at bottom, their claim is that Peru, through its measures, destroyed the value of the bonds and correspondingly failed to pay the so-called intrinsic value, the value that they think the bonds are worth. But those things happened well before the treaty entered into force and thus cannot form the basis for a treaty claim. And there's really no doubt about this, that there, and excuse me, can someone advance the slides? Thank you. There can be no doubt about this because Gramercy has said so repeatedly, and even yesterday, for instance, they stated that their alleged investment was a considered strategy to obtain money for quote unquote stagnant debt. So what is stagnant debt? Stagnant debt is long unpaid debt. So they are asking for payment for long unpaid debt, and that's the exact dispute that has persisted for decades. They said in their post-hearing brief that they invested in a right to payment of the land bonds that Peru had not satisfied. Had not satisfied is something that happened in the past. It had been decades since the bonds' face value had become worthless. And then there had been a dispute ever since then as to what amount, if any, Peru would pay for those bonds. That is the crux of the dispute, and that dispute has pre-existed for decades, well before the treaty entered into force. And what is a dispute? At bottom, a dispute, again, is a disagreement about rights, a disagreement about legal rights. Here, the dispute is, what are Gramercy's or any other bondholders' rights to payment of those bonds? That's the dispute. And when you're looking at whether a dispute pre-existed, you need to look at what was the previous dispute and what is the current dispute. And how do you tell if disputes are the same or they're different? Well, the test is whether they concern the same subject matter. And we know that this concerns the same subject matter because we know what Gramercy did. They didn't make an investment in, well, certainly not within the meaning of the treaty and not within any normal understanding of the term. What they did is they purchased pre-existing claims. And when you look, they even have said that they became a party and took over some pre-existing litigations. And they've discussed at length the Pamalka litigation. So what was the basis for the Pamalka litigation? What were they seeking in the Pamalka litigation? And you've heard about this expert opinion that Gramercy has talked about that was submitted in that case. That expert opinion sought payment on the bonds at CPI, well, to value the bonds using CPI, as well as compound interest annualized from the date of issuance of the bonds. It's the exact same thing that they're seeking in this arbitration. And that was a pre-existing dispute that has been disputed for ages. So I am now going to refer to some confidential materials. So I ask if we can just go into confidential session and let me know when I can begin speaking. Please.
Okay, thank you. Yes, just give me a few seconds. Okay, the non-disputing party is back in the hearing room.
Thank you. So I was just saying how unlike this is from an ordinary investment treaty claim where you have an investor that makes an investment, there is a measure that they believe is unlawful, and that measure causes them harm, and they bring a claim. Here, Gramercy acquired a dispute with the objective of resolving that dispute, resolving that claim. There was nothing more to it than that. And yesterday, Gramercy explained what they invested in was the hope that they could resolve this stagnant land bonds debt. That is a pre-existing dispute. They purchased it hoping to resolve it. And they say that time and again. They say this was the time for Peru to finally clean up this lands bond debt. So as Gramercy said yesterday, once again, they emphasized repeatedly that this debt had remained unpaid for 40 or 50 years. And they said, quote, Peru must now at long last be compelled to pay what it owes. This is using the treaty as leverage in order to get that resolution to this pre-existing dispute. And this is the same thing as occurred in Phoenix Action. It is no different than in that case where the claimant acquired an investment that was already burdened with litigation. All of the damages had already occurred and when the alleged investment was made. And that's the same thing here. All of the damage, the non-payment of the bonds that had already occurred by the time Gramercy acquired the land bonds. They had remained unpaid for decades. And then Gramercy stepped in and purchased them in order to try to resolve the dispute to its satisfaction. Now, in Phoenix Action, that was an abuse, and this is an abuse as well. But here, because of the timing, it is also runs afoul of the non-retroactivity principle and results in a lack of jurisdiction of this tribunal. Now, secondly, Gramercy's claim also runs afoul of the 3-year prescription period. As you know, the treaty establishes a clear and rigid 3-year prescription period, and where no claim may be submitted to arbitration if more than 3 years have elapsed from the time that the claimant acquired or should have first acquired knowledge of the alleged breach and knowledge that they have incurred loss or damage. Now, of course, there can be no treaty breach before the treaty enters into force. And so in that regard, this is fundamentally different from the non-retroactivity principle that I just discussed. And what's important here, though, is that you look at the date of when is the first date after the treaty entered into force where they're alleging there was a breach, and when did they first acquire knowledge of loss or damage. Now, the record is clear that they first appreciated alleged loss and damage and breach no later than on July 16th, 2013, the date of the 2013 Constitutional Court decision that we've heard so much about. And Mr. Koningsberger in the February hearing, said, no, we had no idea what to make of the July 2013 ruling. And, he's trying to distance Gramercy from that critical date because of this prescription period problem. But the contemporaneous documents show otherwise. And you've seen here before the email chain between Mr. Koningsberger and Mr. Serratelli, where on the very day that that constitutional tribunal decision is rendered, Mr. Koningsberger says, where did they come up with this nonsense? So he's read it. He knows he doesn't like it. He calls it nonsense. And then the response is, this is different from what we expected. We expected to represent a significant haircut. It doesn't matter that he can't quantify or doesn't quantify the haircut. He is saying this is different from what we expected. We don't like it. There's your breach. And your first appreciation of loss or damage is that you expected to represent a significant haircut. And why is this? Because it's clear on the face of that resolution that the Constitutional Tribunal had not adopted CPI and interest from the date of issuance. That was Gramercy's main points that they are still making here, that they've made in the Pamalka case. That's what they've been seeking. And it was clear on the face of that resolution that that's not what the court adopted. So they immediately knew this doesn't comport with what we want, hence in their mind a breach. And it was going to result in lower payments to them, hence an appreciation of loss or damage. Now, in their post-hearing brief, Gramercy characterizes this email exchange as a hasty email that was written by a quote unquote single Gramercy employee. But at the hearing, Mr. Janot testified that Mr. Serratelli was, quote, Gramercy's main man in Peru. He was the one who was most deeply involved with the acquisition of the land bonds and being there with respect to the land bonds. So that's simply not credible. But there's also additional evidence in this regard. The following day, the very next day, a Gramercy affiliated expert states that creditors might sue Peru in foreign or international court, clearly appreciating the alleged loss or damage. And then we also have privileged withheld documents within a couple of days that they prepared in anticipation of litigation and withheld. Now, yesterday, they also, in February at the hearing, Gramercy argued that they didn't have any appreciation of loss or damage until the issuance of the Supreme decrees in 2014. But again, that is belied by the evidence and in fact by Gramercy's own statements, even as recently as yesterday, when Gramercy stated, and I quote, they understood that what the CT had ordered in July 2013 was something different. It understood it might have an adverse impact on its investment, but the extent of that impact wouldn't become clear until months later. Again, the jurisprudence is clear, and this is a point on which the United States and Peru have expressly agreed, and that agreement shall be taken into account by the tribunal, that you do not need to appreciate the full extent of the damage that you have suffered. What matters is the date on which you first appreciated that you have suffered some loss or damage. So the fact that they didn't understand or appreciate the full extent of the damage is legally irrelevant. This is a clear concession that they understood on that date that the Constitutional Tribunal's decision had an adverse impact on their alleged investment. And they state this throughout their post-hearing brief, in fact. They call the decision the smoking gun. They say it has features, it's error-filled, it's a flawed premise. Again, what they're getting at is that it doesn't adopt CPI with interest from the issuance date. That's easy to see, not something that would take them a long time to find out. They knew it on the day it was issued, and not something that would take them any time at all to realize that it would result in a valuation far below what they have claimed that they're entitled to. And again, recall, in Gramercy's initial pleading, they stated, and I quote, "The government's intentions became apparent on July 16th, 2013. Now, it was only later that they shifted their focus to later events when they appreciated the problem that they had here with the prescription period." And that problem, as you can see here, is that they did not submit their claims to arbitration until, and GPH, excuse me, did not submit its claim to arbitration until August 2016, which is after that critical date. Now, recall yesterday, in response to some questions from the tribunal, when the issue came up that this objection only applies to GPH. And counsel stated, well, you know, that's okay, because if you have jurisdiction over GFM, you can award damages to GFM, quote unquote, on behalf of GPH. But no, you can't do that. There's no provision in the treaty that allows a claimant to stand in the shoes of another claimant over which the tribunal lacks jurisdiction and to award to this other claimant damages suffered by the claimant over which you lack jurisdiction. So you can't do that. So that is why this does remain important, and also because GFM, in addition to GPH, clearly is not an investor, as my colleague, Mr. Ulrich, will discuss in just a few minutes. Now, the problem with the prescription period stems from the fact that they did not submit compliant waivers until August of 2016. And it is clear from the treaty itself, as well as the US submission, as well as jurisprudence, that no claim can be submitted to arbitration until you submit a compliant waiver. And it has to be compliant in both form and in material respect. And that's a condition precedent to the submission of a claim to arbitration. Now, counsel yesterday said, quote, "A qualified waiver is perfectly consistent with the treaty." But no, it's not. The very words of the treaty say otherwise, as does consistent jurisprudence, as does the agreement of the United States and Peru. Counsel also went on to say, even if it weren't, an imperfect waiver is still enough to stop the clock on the time bar. That too is incorrect. For that proposition, as you know, counsel has relied on the Renko 2 decision. Now, Renko 1, to take you back to that, confirmed that an improper waiver is not a trivial defect, but a defective waiver goes to the heart of the tribunal's jurisdiction. And Renko 2 doesn't change that in any regard. Now, Gramercy has placed into the record for the tribunal's consideration, and it's going to rule on the issue, I believe, after the hearing, the majority opinion in Renko 2. And it says that the tribunal's majority agreed or found that the submission of a statement of claim in the earlier arbitration, even though that arbitration was dismissed for lack of jurisdiction, it suspended the running of the prescription period. Now, that is simply wrong. And I have quoted here from the dissent, which Gramercy did not include, nor did they make reference to the US submission in this case, which is also contradicts the Renko 2 tribunal's ruling in that regard. As the dissent explained, the majority has engaged in an excess of jurisdiction by arrogating for itself a power which it clearly doesn't hold. And the contracting party's agreement, again, is that the date of submission of an effective waiver is the date on which the claim has been submitted to arbitration for purposes of 10.18.1 of that treaty. Now, To just give you a hypothetical example, to put this very clearly in perspective and to explain why that decision of the majority in Renko 2 is clearly improper and is not only contrary to the parties' agreement, but beyond the tribunal's jurisdiction. I just want to explain how that decision both renders ineffective both the prescription, the time bar provision in the treaty, as well as the waiver provision. And it is contrary to the object and purpose of the treaty. So if you imagine that a party has a claim in domestic court and then wants to bring a claim in arbitration, under the treaty, they can do that as long as, if it's running up against the 3-year period, they have to discontinue their domestic court proceeding and then go to arbitration. They have to waive their right to continue the domestic court proceeding. But let's imagine they don't do that, which is what Gramercy did here. They put in the written waiver, but they don't discontinue the proceeding. That is a material waiver violation. Tribunals, Waste Management 2, other tribunals have clearly found that is a violation that will render the tribunal without jurisdiction. Now, in that event, what if the state party then raised an objection to jurisdiction on the grounds of the material waiver violation? It goes through a briefing, it goes through a hearing, it takes 2 years. The tribunal renders a decision, dismisses the case for lack of jurisdiction. By that time, the prescription period is run. It's been more than 3 years, but they're still going ahead in court. They wait another year while they go through the court proceeding. They get a court decision, they don't like it, it's unfavorable. So they file a new arbitration. By any standard, that new arbitration should be time barred. What Renko 2, what Gramercy wants you to say is, no, it's okay, because we're going to consider that it's not time barred. We're going to look at the time when you initially submitted that claim to arbitration. That cannot be right, because it renders the prescription period entirely ineffective. It renders the waiver requirement entirely ineffective. That simply cannot be correct and should not be followed here. And finally, very briefly, I want to make a few comments on abuse. Because in addition to the lack of jurisdiction, the claim is also inadmissible because it is abusive. Even if there had been no jurisdictional bar, acquiring an investment that's subject to a pre-existing dispute is abusive, because just like the tribunal in Phoenix Action stated, that type of an investment is not made in order to engage in national economic activity. It's made in order to transform a pre-existing dispute into an international dispute, which is exactly what Gramercy did here. Now, as the tribunal and Philip Morris explained, an abusive right also applies when there is an existing dispute, although in many cases there will be a jurisdictional bar as well, as in our case. Now, even if you find, however, that there wasn't a pre-existing dispute, Gramercy's claim is still inadmissible as an abuse because the dispute was reasonably foreseeable. And as the jurisprudence shows, an abuse can be found when a party engages in corporate restructuring, the same thing as acquiring an alleged investment, in order to gain access to treaty protection, in order to bring a dispute that is foreseeable. And what does it mean if a dispute is foreseeable? It means that it's within the reasonable contemplation of the investor. If there's a reasonable prospect that the measure which may give rise to a treaty claim will materialize, and the amount of time it takes for that claim to materialize, that treaty claim or legislation or something like that, is not determinative as to whether it's foreseeable or not. Now here, at a minimum, this arbitration was clearly within Gramercy's reasonable contemplation when it acquired the land bonds. What did Mr. Koningsberger testify to? Once again, he testified that Peru wanted to kick the can to the next administration. They just didn't want to deal with it. They waited till the next president, see if that administration will deal with it. If not, they kept kicking it down. This happened for decades. Was it reasonably foreseeable that that would continue to happen? Of course. Was it reasonably foreseeable that they wouldn't get this grand, virtuous circle of a resolution, whatever that means? Of course it was. Was it reasonably foreseeable that they would end up in a dispute, a treaty dispute? Of course it was. He goes on to say, that of course we knew there was an investment treaty. That was a valuable safety net. But more than that, they said yesterday, Gramercy invested because it saw an opportunity to resolve the land bonds debt. And Gramercy understood that receiving payment on the bonds would likely take time and effort. It might require consensus building and compromise, and perhaps even assertion of legal rights associated with the bonds. Of course it might, because this had been a long-standing dispute. Of course it was reasonably foreseeable that it would end up in arbitration just like we are now. So with that, I'm going to pass the floor to Mr. Ulrich, who will talk about the lack of an investment and investor. Thank you.
Thank you. Mr. Ulrich.
Thank you, and thank you, members of the tribunal. Let me jump right in here. Even if you set aside the fatal jurisdictional flaws just covered, the fact remains that Gramercy didn't make an investment under the treaty, and neither claimant is an investor under the treaty. With respect to investment, the treaty definition is clear and requires an assessment of the characteristics of an investment. The contracting parties agree that this is an important requirement. You didn't hear once from Gramercy yesterday about the submission of the United States providing its views, really the agreed views of both contracting parties on various points of interpretation of the treaty. You did hear Gramercy's attempt to equate the land bonds with other types of bonds, like comparing two types of cars from different eras, they say. But that's not the relevant inquiry, as Professor Reisman concluded. One must always assess on a case-by-case basis the characteristics of investment. Now, the contracting parties also agree that the enumeration of a type of asset among the treaty's illustrative examples is not dispositive. Nonetheless, you heard yesterday that because bonds are mentioned, they are presumed to have the characteristics of an investment. This was the refuted direct testimony of Gramercy's expert, Ambassador Allgaier, who had said he was thoroughly familiar with the US government's understanding of its treaties. On cross-examination, Ambassador Allgaier wasn't familiar at all with the US government's submission on this treaty in this case. This treaty says nothing about a presumption. The contracting parties have said nothing about a presumption. The ambassador also repeatedly acknowledged that treaty interpretation is not within the scope of his expertise. The negative list to approach to negotiations. This is another point covered by Ambassador Allgaier. This too cannot obviate the assessment of investment characteristics. On the ambassador's reading and Gramercy's, every single asset under the sun that is not expressly identified by the contracting parties on an exclusion list is automatically protected by the treaty. That completely deprives the investment characteristics requirement in Article 1028 of any meaning. The negative list is a negotiating approach. It's not a legal requirement. It's not a treaty requirement, as the ambassador acknowledged. It doesn't control the analysis. Now, consideration of investment characteristics. Gramercy is skeptical that the Cellini factors could apply in an UNCT trial proceeding. Professor Reisman, Peru's expert, also has been skeptical. He's been critical in other cases under other treaties. But who better than a Cellini skeptic to explain why Cellini is relevant in this case under this treaty? As Professor Reisman explains, Cellini and its jurisprudence are relevant to understanding the treaty precisely because the treaty refers to the characteristics of an investment. An interpreter, he says, has no choice but to apply them. Applying these criteria, we see that a treaty investment requires that an investor make its own contribution. It doesn't make an investment merely by receiving an asset, let alone by inheriting control of an asset years after the fact. A number of tribunals, some mentioned here, others in our briefs, have ruled on this need for an investor to make its own contribution and not to act merely as a conduit for contributions by third parties. By the same token, an investor must assume its own risk. And in the investment treaty context, the jurisprudence shows we're not just talking about commercial risk, like the risk of non-payment under a contract or under a debt instrument. Investment risk means operational risk tied to the success or failure of an economic venture. As the Postova Banca v. Greece tribunal ruled, that's not the kind of risk involved even in the acquisition of sovereign bond interests. A treaty investment requires a certain duration. We see here that the FedEx tribunal cautioned against short-term arrangements where an investor seeks to make quick gains and then leave. And in KT Asia, the duration tribunal ruled that where the investor's plan was to turn around and sell the interest to third parties, the duration element was not met just because that onward sale to monetize the asset took longer than originally planned. A treaty investment requires a contribution to the host state's economic development. As Professor Reisman testified, this is relevant because it's reflected in the preamble of the treaty, where the contracting parties resolve to promote broad-based economic development, also a latent purpose of this entire genre of treaties. Here again, the jurisprudence draws a distinction between a treaty investment and an ordinary commercial transaction. For fuller treatment of the preamble, including other elements of the treaty's object and purpose which must be considered when interpreting the treaty, I refer you to our briefs in the interest of time. Now, Gramercy's alleged bond investment doesn't meet any of these investment criteria. Not its own contribution, not risk, not duration, not contribution to Peru's economic development. Much of the evidence relevant to this analysis has been designated confidential by Gramercy, so I need to ask that we enter into closed session, please.
The NDP is back into the hearing room. Thank you.
Okay, thank you. All right, let's discuss contribution to Peru's economic development. There wasn't any, not from GFM, not from GPH. Now, we heard repeatedly yesterday that Gramercy planned to create a virtuous circle where it could catalyze a resolution of the bonds, supposedly with a wide range of corresponding benefits for Peru. But that alleged plan never materialized. In reality, Gramercy made one-off payments to bondholders using third-party funds. Gramercy repackaged bond interest for sale to third parties outside of Peru, and Gramercy generated fees for itself outside of Peru. Far from contributing to Peru or to any economic venture creating value in Peru, Gramercy actively engaged in measures to undermine the economy in an attempt to pressure Peru to settle. That's not the type of conduct an investment treaty is meant to protect. A quick note on Gramercy's two experts, Ambassador Allgaier and Professor Olivares Caminal. Neither had assessed the actual circumstances of Gramercy's bond acquisitions. They hadn't seen the purchase contracts. They weren't aware of the funding arrangements. As Ambassador Allgaier said, for example, I am totally unfamiliar with the bonds themselves and the transactions that took place. In other words, they assessed the concept of bonds in a vacuum, entirely devoid of context, without any consideration for the actual characteristics of Gramercy's alleged investment in this case. That is contrary to what Article 1028 requires. Now, jurisprudence on contemporary sovereign debt reinforces that the bonds are not investments under the treaty. We heard yesterday from Gramercy that, quote, Peru has never attempted to distinguish this case from all the other cases in which tribunals have found government bonds are indeed investments. Well, that's not true. In fact, Peru introduced the analysis of this jurisprudence in its statement of defense because Gramercy didn't mention any of these cases in its statement of claim. Peru also addressed the cases later in briefing and also at the hearing, as we see an example from a slide in our opening argument and conclusions by Professor Reisman, saying that the land bonds are nothing like the bonds at issue in Abaclat v. Argentina. This record speaks for itself. The treaty negotiating history further confirms Gramercy didn't make an investment. As we see here, the testimony of Peru's witness, Mr. Herrera, the chief negotiator for Peru, and Gramercy's expert, Ambassador Allgaier, is aligned. The bonds were never discussed at the negotiating table and are not mentioned in any of the minutes of the 13 rounds of treaty negotiations. This hardly supports Gramercy's theory that the contracting parties were mindful of the bonds, specifically accounted for them in negotiations, and intended for them to be covered under the treaty. Now, Ambassador Allgaier also testified that a number of pre-treaty disputes involving U.S. investors regarding the land reform were a, quote, proverbial sword of Damocles over the negotiations. As we saw at the hearing, those disputes concerned expropriated property, not bonds. For example, the Laterno case concerned a dispute over payment for a road, which had been adjudicated in Peruvian court. It wasn't a dispute over the bonds. Ambassador Alguerra ultimately admitted that he hadn't gone into details of that case or any of the other cases his report had referenced. And as contemporaneous diplomatic cables also showed, the U.S. Embassy in Peru actually recommended the removal of a number of cases from consideration due to lack of continued involvement of the investors. This is hardly evidence that the land bonds were a burning issue at the treaty negotiations and that the contracting parties specifically intended that they would fall under the protection of the treaty. The link Gramercy has tried to manufacture here does not exist. If I may briefly make one further point here, and then in the interest of time, we're going to pass it back to Ms. Menaker and on to further issues. And this issue I'm going to address is that of the beneficial owners. So we see a critical issue that came to light only years into this proceeding with revelation of materials with Gramercy's statement of reply is the particular nature of the beneficial owners of Gramercy's alleged bonds. As we've briefed, I'm not going to go over it again here, Gramercy doesn't have standing to bring claims with respect to the interests of third-party beneficial owners. Can we advance the slides, please?
I understand that it is Ms. Menaker now. You have the floor.
Mr. President, members of the tribunal, and now I will address the merits of Gramercy's claim, and I'll begin with expropriation. Now,
hello, Ms. Menaker. I'm sorry, can we invite the NDP back into the room?
yes.
Thank you.
Just let me know when I can begin, please.
The NDP is back in the room. Thank you.
Thank you. So Gramercy's expropriation claim fails at the threshold because it cannot show that Peru has destroyed all or virtually all of the value of its investment, which is of course the requirement for one of the requirements to show an expropriation. The bonds admittedly were worthless on their face well before Gramercy acquired them and well before any of the challenged measures. And this destruction of the bond value was neither unlawful, nor did it occur after the treaty entered into force. Now, yet in their post-hearing brief, Gramercy said that Peru does not dispute that Gramercy's purchase price represented a steep discount to its land's bonds value, true value, and that the reason for the discount was Peru's own conduct. And yesterday, Gramercy said, quote, "It was the government that confiscated land the size of Portugal and did not pay for it. It was the government that drove the economy into the ground and initially undercut the value of the debt." However, it's undisputed that the bonds became virtually worthless as a result of years of economic instability and severe inflation, not because of any unlawful conduct by Peru. And in any event, this conduct occurred well outside of the time that the treaty was in force. And Professor Edwards recognized this. It was a result of severe hyperinflation that rendered the bonds facially worthless. In any event, the value of the bonds has not been destroyed by Peru's actions because Peru has offered substantial compensation to Gramercy as well as other holders of bonds that have been authenticated. But Gramercy chose to refuse that compensation. As you've heard many times, Gramercy paid $33 million for these bonds. If they had gone through the bondholder process, they could have obtained $34 million. Now, yesterday, Gramercy said that the bond process offers, quote, "trivial amounts of money of which the society should be ashamed." At the same time, Gramercy yesterday said that the sellers, the Peruvian bondholders that sold them their bonds, agreed to sell them to Gramercy because Gramercy paid them fairly. Now, members of the tribunal, these two statements are simply irreconcilable because Peru is offering essentially what Gramercy paid for the bonds, which means that the bondholders who sold to Gramercy would have gotten approximately the same amount had they gone through the bondholder process. Now, some of them, as you've seen, could have gotten more, would have gotten more. Some would have gotten slightly less, but on average, approximately it's the same amount. They can't, on the one hand, say that they treated these bondholders fairly. They paid them amounts that were fair, that represented the value of the bonds, and that they should be happy. And these bondholders are very, very happy to have received this from Gramercy, and at the same time call it shameful that Peru would have offered them the same amounts and would offer Gramercy the same amount. That's simply irreconcilable. The other thing that defeats their expropriation claim is their tranche 2 purchases. And you heard nothing about this yesterday from Gramercy. 2017, well after any of the acts that Gramercy is now complaining about in this arbitration, they went out and purchased additional bonds. Now, when can you ever imagine a claimant having an investment that has been expropriated and then they go out and they purchase that same investment? Of course not. It had to have had value. It could not have been substantially devoid of all value if they went out and they actually purchased additional bonds. Now, the other aspects that one looks at when determining whether there has been an expropriation, in addition to showing that the financial impact, that it was all or virtually all destroyed, you look at the character of the measure and whether there have been reasonable investment-backed expectations that have been quashed by the measures, and both of those factors also doom their expropriation claim. Now, with respect to the character of the measure, that's because this measure at issue here, the bondholder process, it applied to all bondholders. It was of general application. It served a legitimate public interest of resolving a decades-long dispute. It was implemented on the basis of fundamental public welfare objectives, including promoting the public general welfare, providing basic services, ensuring that there was money available to provide those services, etc. Yesterday, counsel referenced the Siemens case and said that's insufficient. The Siemens case is inopposite. That case concerned a measure which was a government decree that terminated the claimant's contract. The claimant had what amounted to a 12-year-long contract, and pursuant to decree, the government terminated that contract. That is a specific measure aimed at a specific claimant. It is not a measure of general application that is adopted in pursuit of these objectives here, and is completely inapposite. Now, with respect to reasonable expectations, we have shown at length this morning that Gramercy had no reasonable expectations. They knew that the bonds were subject to long-standing uncertainty and dispute. And in the interest of time, I'm not going to repeat all of that here. In fact, I'm not going to repeat any of it here.
This is confidential, I believe, a confidential slide.
No, I'm not. We're skipping over those slides in the interest of time. And I'm only going to mention that you've seen time and again the consistent lobbying. If they had reasonable investment-backed expectations, that means that there was certainty. You wouldn't be lobbying. What are you lobbying for to change the law if there is certainty? Why are you going to court if there is certainty? Why are you only floating a test case? But I urge the tribunal to look at the various additional quotations on the slides when you have time. Now, with respect to the minimum standard of treatment claim, that claim is largely based on an argument that there has been a violation of fair and equitable treatment because Gramercy's legitimate expectations have allegedly been frustrated by Peru's measures. And that claim is also doomed to fail because while legitimate expectations are a factor that is taken into account in an expropriation, it is expressly not a part of the customary international law minimum standard of treatment. On this, the contracting parties to the tribunal agree. You have jurisprudence from tribunals interpreting treaties similar to this one, as well as ICJ jurisprudence showing that. So then when you look, what do they have left? When you're looking at a fair and equitable treatment standard, violation in a non-judicial context, the standard is indisputably very high and they have not come close to meeting it. Instead, they rely on a host of arguments that these measures were contrary to Peruvian domestic law, but that alone is woefully insufficient to show a customary international law minimum standard of treatment violation. Yesterday, Gramercy focused on some alleged domestic law violations and discussed in particular the pre-publication requirement under Peruvian law. And it said that this requirement in fact emanated from our treaty itself and then was enacted into law in Peru in order to implement the treaty's requirements. But that does not make non-compliance with that provision an FET violation. And it's quite the opposite, because our treaty has express terms that says a breach of another provision of this treaty does not constitute a breach of the customary international law minimum standard of treatment. And the tribunal will recall that the Metalclad versus Mexico decision was partially annulled, partially set aside for this very reason. That tribunal found a violation of the minimum standard of treatment on the basis of alleged violations of transparency obligations that were part of other chapters of the treaty. And the court that set aside that award partially on those grounds said those other violations do not constitute minimum standard of treatment violations. So instead, you have a host of complaints about the process that my colleagues discussed this morning in a lot of detail, so I won't repeat that here, but to say that also their complaints about alleged lack of consultations are inapplicable. This is not a restructuring, a global restructuring. They have pointed to no binding international, customary international law that would require the kind of procedure that they now are looking for. And at the end of the day, really, this is just post hoc complaints by them, because as my colleagues also showed, they didn't boycott this process because of these alleged procedural defects, of these shortcomings. At bottom, they did not like the valuation. They did not like the amount of money that they would get from this procedure. And that's what their complaint is. And that is something that is well beyond the purview of this tribunal to review and to decide that that would constitute a violation of the customary international law minimum standard of treatment. And again, FET clearly does not provide an insurance or a guarantee for speculative investments. When you look at the Anton versus Spain case, I think it's quite instructive, because there you had also a regulatory system that was in flux. You had people coming in, investing in solar power, but the market was overheated and the government was talking about having to do something about it. They were debating what kind of legislation could we put in place, what new regulations. And this investor ran in, knowing this in the background, made an investment, and then when the law did change, they said, oh, wait, look, our expectations have been frustrated. This is an FET violation. The tribunal dismissed that, and they called that investor's actions opportunistic. That fits Gramercy to a T. They're opportunistic. They piled in to take advantage of laws which they knew were in a state of flux. All they had was the speculative hope. That hope is not protected by the minimum standard of treatment. You know, very briefly, Gramercy yesterday did not even address their denial of justice claim, and that's clearly why they didn't do so, is because they don't have standing to bring one. All of their complaints are with respect to the 2013 Constitutional Tribunal decision, and they were not a party to that claim, that case. And we pointed this out, and they had no response whatsoever. So they can't bring a denial of justice claim. So now they've tried to bring an effective means claim. They can't do that either. They can't import the effective means provision through the MFN provision into this treaty. Both of the parties agree on that. It is clear in the text of the treaty itself. It just simply cannot be done. But at bottom, it fails for a number of different reasons, in addition to all of the reasons we've discussed when we've discussed the substance of the 2013 Constitutional Court decision. And finally, with respect to national treatment, on which Gramercy again spent very little time yesterday, that claim also necessarily fails. They have not even identified a relevant comparator. They're purporting to compare themselves to all the Peruvian bondholders which are largely comprised of a group of individuals with comparatively small holdings in various different circumstances. But anyway, they haven't shown any disparate treatment on account of nationality, which is what the national treatment obligation protects. And at bottom, their national treatment claim rests on an irrelevant payment structure for small payments. Yesterday, Gramercy said, quote, "It was the last in line to receive payment." That is gross misstatement, or it grossly misconstrues the nature of this provision in this decree. All this decree says is that when you go through the bondholder process, you get paid in bonds. However, for $30,000, you can opt to get cash. But if the government runs out of cash, then they have an order of priority, which means for Gramercy's $1.8 billion claim or $840 million claim, it would have been maybe entitled to get $30,000 of that in cash if they were in the order of priority and the government hadn't run out of cash. This cannot form the basis for a national treatment claim. As the president recognized at the February hearing for this arbitration, this provision, it's irrelevant. It may be important for small bondholders, not for Gramercy. Gramercy in any event didn't participate in the process, and all along it said it was happy to receive bonds. So with that, I thank the tribunal for its attention, and I turn the floor over to my colleague, Mr. Llano.
Thank you. Let me get a time check from the secretary.
Mr. President, the respondent has 1 minute of his time left.
Very good. I think Dr. Llano, you wanted to say, to take the floor?
Yes, Mr. President, if you can give me 5 minutes.
Of course. No worry.
Okay, I will cover a handful of slides.
But it's better if you go slowly and you try to focus your comments to what is really important, rather than trying to cover too much terrain.
Absolutely, I agree.
Thank you.
Thank you, Mr. President and members of the tribunal, for your attention and patience today. Gramercy's damages case is a jumble of inconsistent figures and valuations, cherry-picked from a number of variables to suit their taste for a number that they're looking for. But before this tribunal can even consider stepping into this morass of numbers, it is key to address a series of threshold issues which Gramercy either confused or left unaddressed yesterday. The first set of questions is, who is Gramercy? And why is Gramercy, as opposed to some undisclosed third-party investor, entitled to any damages on the facts of this case? The answers are that Gramercy is merely a vehicle for other people's money, and that it is therefore not entitled to any damages in this arbitration. More specifically, Gramercy has failed to prove any investments by claimants not made on behalf of third-party beneficial investors other than a de minimis ownership share by GFM. Gramercy also has failed to prove any damages to either claimant other than supposed loss management fees. In fact, as testified by Mr. Lanava, which you can see on the screen, and that is Gramercy's chief compliance officer in his second witness statement, when and if Gramercy monetizes its land bonds investment, whether through a settlement with Peru or through an award in this arbitration, the proceeds will be distributed by PARB exclusively to the existing owners of PARB, according to their ownership in PARB on our official books and records. PARB, or Peruvian Agrarian Reform Bond Company, is a Cayman Islands entity that owns GPH, one of the two claimants in this case. And that is why Gramercy wasn't even clear in its requests for relief as to whom any proceeds from this arbitration would need to be awarded to. Claimants suffered no damage and have proven none. At most, claimants would get to keep whatever management fees they would be entitled to for pulling off such an extraordinary outcome. But as also mentioned on this slide, Gramercy has not provided any evidence as to the amount of such management fees. And in any event, Gramercy has been collecting management fees for years on the back of hyperinflated valuations of the land bonds. Again, no damages proven here. Gramercy has also failed to provide its financial models underlying its internal valuations and to provide financial statements or valuations coming from either claimant. In short, this is not Gramercy's claim. It is a claim that they have sold to third-party investors who appear to have been taken in by self-sustaining valuations for years. No damages to either claimant have been proven, and we will provide a context at the end of this very brief section and references to evidence when we go into confidential session. Gramercy also has failed to establish and then satisfy a proper legal standard for damages in this case. As Mr. Kaczmarek and Ms. Kunzman explained in their first quantum report, a damages case in an investment treaty arbitration must be anchored in an appropriate standard, and tribunals most often adopt the fair market value standard. That standard makes sense here precisely because there was so much uncertainty regarding the valuation of the land bonds at the time when Gramercy acquired its bonds. But Mr. Edwards disclaimed all that. He disclaimed all knowledge of Gramercy's expectations. He disclaimed all knowledge of Gramercy's due diligence. He disclaimed any concern with applicable standards in treaty arbitrations. In fact, when I asked him a question about whether he had any understanding about what the expropriatory act at issue would be, I was met with an objection from claimants, which is telling, because any meaningful valuation would take into account the timing of the acts at issue. Mr. Edwards's calculations are divorced from any understanding of claimant's facts and claimant's case, and the convenient use of the all-purpose phrase intrinsic value does not bridge this gap.
Mr. President, forgive me, Mr. President. You are on mute, Mr. President.
Sorry for that. No, I think, Mr. Friedman, you are going to say how long does Mr. Llano have to go?
In a slightly stronger form, which is that this is the second time, because it happened at the opening arguments, oral opening arguments as well. I just want to make sure the rules are being applied equitably to the sides. You will recall that both at the opening and for this oral closing, we had proposed slightly longer periods of time of 3 hours, which Peru objected to and cut back and said should be 2.5 hours. We then worked quite hard to be as disciplined as we could and felt sometimes we had to go faster than we wanted to in order to stick with what the tribunal had said. And so we left a lot of material on our cutting room floor out of being disciplined and respectful to what the tribunal provided for. Of course, we all appreciate that if you run over by a couple of minutes because you want to wind up, nobody's objecting to that. But I note that Mr. Llano is sort of in the middle, or he's still at sort of the beginning of a whole series of slides on this topic. And I just think it's rather, it's sort of unfair to have left us in a position for the second time where we had to comply and there was a lot we didn't get to say because the compression of time. And I think at the opening, if I recall, I think that the respondent ended up taking about 20 minutes more than we did, which is not an immaterial amount of time when you're limited to 2.5 hours. So I would ask that the tribunal simply apply the same discipline. They've allocated their time and made their choices. They really do need to kind of conclude now. At least that's our very respectful proposition and submission to the tribunal.
Thank you, Mr. Friedman. Mr. Llano, I have, how long do you have to go?
2 slides.
Okay, you must come to an end now. Huh? You must wrap up your arguments, and if so, because I have some sympathy that you are really the last to speak, and we compressed the presentations to 2.5 hours, and we should try to stick to that. So please, 2 more. And please, let's not make these old Spanish jokes that the 5 continents are 4, Asia and Europe. Let's make it 2 slides.
2 slides, sir. Thank you. So I have, in these 2 slides, I have 2 points to make. One is about intrinsic value, and the other is about what is Gramercy's claim at the end of the day. So on intrinsic value, what I want to say is this is just a euphemism for whatever Gramercy sees fit to claim. Whether it's $300 million or 800 or 1.8 billion. And as you can see on this slide, Mr. Edwards on cross-examination was taken to his first report, his submission in chief, and he provided no connection between his so-called intrinsic value calculations and any understanding of Peruvian law. He just came up with a high number. It's totally unilateral and totally circular. The number is not based on any market, any comparables, any certainty, any parameters. And the other point I want to make just to conclude on this slide is that we heard yesterday in Gramercy's closing argument that intrinsic value is supported by legal authority. We respectfully disagree. Gramercy on slide 151 of its presentation cited to FedEx v Venezuela, Brazilian loans, Serbian loans, and Vigotop. Not one of these cases even mentions the phrase intrinsic value. FedEx, which we show here, literally awarded the face value of the promissory notes at issue, the amounts that were specifically recorded in terms of principal and that correspond exactly to the calculation of interest. Brazilian loans awarded the precise amounts on the face of the loan contracts. Same with Serbian loans. Vigotop is not even on point. Intrinsic value is a meaningless phrase. It is not a standard, and to put it in the same sentence together with fair market value is ludicrous under international law. So now I will go, as I promised, to one of the final slides.
To your slide, to your final slide. Very good, thank you.
Oh.
You are going to the values of your firm, which are important, but probably you want to go 1 slide before that.
If my colleagues can pull back up the presentation, last slide.
The value of your firm is never go 1 step back. And this is why you are unable now to go one slide back.
That's okay, Mr. President. We've dealt with worse. So I will tell you the point. Mr. President, Gramercy's claims at the end of the day turn on a claim that was purchased from Peruvian bondholders. It was purchased at a price, 33 million. And it was purchased at that price for a reason, because there was no market and there was no certainty. And uncertainty carries a price. That price was factored into the market value of the bonds that Gramercy purchased. But it is not, that uncertainty is not factored into the valuation that was provided by Mr. Edwards. And the fact that Mr. Edwards was compelled to provide not 1, not 2, but 7 different alternative quantifications, all of which purportedly are conveniently consistent with the notion of intrinsic value, shows you that there is no basis here for legitimate expectations. There is no basis for a claim of certainty. And the suggestion that was made yesterday that intrinsic value applies when you have a some certain that is taken away from you is exactly the opposite of reality. Reality is there was no certainty. There were no legitimate expectations other than uncertainty, which is Gramercy's business. Gramercy purchased a claim. I will not get into the specifics to avoid any confidentiality issues, but this is the core of the issue. They bought a claim. That's all they bought. No certainty, no legitimacy. This is an abusive claim and it should be dismissed with costs. I thank you very much, Mr. President and members of the tribunal. I thank you especially for giving me this one last minute. Thank you.
Thank you, Dr. Llano. With that, we finalize the presentation of the Republic of Peru. We will now break for a quarter of an hour, if that is agreeable. Could I see, because I only see Dr. Llano, maybe Mr. Friedman or Dr. Popova could come up. Yes, thank you, Mr. Hamilton. So if this is agreeable to you, we will now break for a quarter of an hour, and we may or not have some questions to you.
Of course.
Is that agreeable?
Of course, Mr. President.
So it is now 18:15. We will endeavor to be back by 18:30 French time, which is whatever time is in America.
12:30 on the East Coast of the United States.
12:30. We promise that we will let you off to a lunch in good time in America and to dinner here in Europe. Thank you. Yeah. And we now break into our breakout rooms.
Hello again.
Re buenas tardes.
Re buenas tardes.
We have Mr. Hamilton with us, Ms. Popova, and is everyone else coming in? Very good. So
let's give Ms. Miniker a moment, if we might, Mr. President.
Of course.
Thank you very much.
So, Mr. Friedman, you are complete with your team?
We are. Thank you, Mr. President.
And Mr. Hamilton, you are complete?
We are complete. Thank you.
Very good. We have a few questions which we have deliberated upon, and on which we would like some further input, short input, because I mean, there is a huge amount of material in the case, and we will, of course, go through all the material. We have first two areas which we would like to hear both parties. One is the 2013 Constitutional Court decision, and then the 3 Supreme Court decrees. And starting with the Constitutional Court decision, we understand that it established the law of the land regarding the payment of the outstanding agrarian bonds. Can we have a very brief summary of what the Constitutional Court said regarding the principle and the interest of the bonds? These two issues which seem important. Mr. Friedman, I give you just these 2 points. What, if you can give us in a nutshell, what did, in your opinion, establish the Constitutional Court as the law of the land regarding principle and interest of agrarian bonds?
Thank you, Mr. President. And we addressed this to some extent yesterday in our presentation, and have some slides where, if I can just recall the slide numbers, I would refer you to them because they are helpful on this topic. Yes. So I'll refer to those in just a moment. The Constitutional Tribunal July 2013 decision considered the issue, of course, against the constitutional and civil law background in which the question of updating the land bonds debt occurred. Right, so it wasn't just an isolated issue. There had obviously been a great deal of litigation in the lower Peruvian courts as well, as you know, over the years about updating value in particular cases. So the Constitutional Tribunal considered what the principle was to achieve the current value, and it was their focus. And I think as Professor Castillo described it during his testimony, and I think actually as respondents acknowledged during their presentation today. Strictly speaking, current value by itself means updating the principal so as to eliminate the effects of time or inflation on that have denuded the value of the bonds, right? So that it restores the original purchasing power of the obligation. And I think the Constitutional Tribunal in 2013, it's quite clear, it's actually in the opinion, explicitly said that that's exactly what that same tribunal had held in the same case back in 2001. That is, the principle is that the legal principle, that's Principle, includes updating the principal, Principal, of the bonds to current value. And that neither the CT 2013 case, nor, as Respondents Counsel correctly pointed out, the 2001 CT decision was about the interest rate that would also have to go along with it to comply with the obligation of the Civil Code. Because everybody understood that if I can speculate a little bit, but I think because everybody understood that was a Civil Code requirement in any event. And that and consequently, the Constitutional Tribunal in 2013 talks about the approach to updating, how they're going to do updating.
And how will they, let's go to that. Let's go into the details of that. How is, sure. Is your understanding of the updating which the Constitutional Court mandates?
What they mandated were certain parameters that they then directed the Ministry of Economy and Finance to implement in supreme decrees. And that was the part I think the ministry actually had the greatest problem was, which is that they were actually being told to do something in an enforcement instance by the Constitutional Tribunal. It was the subject of their later challenges. But what the Constitutional Tribunal said on this can be found in the decision itself. They looked at these different methods, and then in paragraph 25 of the decree, they say, okay, here are the reasons why we are going to select one of these methods, and we think that's appropriate. They describe two reasons for it in Article 25. They say they find it appropriate to opt for an updating criterion that employs conversion of the unpaid principal into United States dollars as of the date of default on the payment of the coupons of the bond, plus the interest rate of the United States Treasury bonds. This is due to the fact that first, the method of conversion to United States dollars has legal precedent in Emergency Decree number 088-2000, which you'll recall was the subject of the court's 2004 decision. That was the optional dollarization approach. And second, because as stated, the other valuation methods described would generate severe impacts on the budget of the Republic to the point of making impractical the very payment of the debt.
Okay.
And so that's what they then prescribed. But they also state, as we indicated in, this is where we indicated in our slide 70 yesterday, in paragraph 28 of the decree, they're directing then what the Supreme Decree must do, what the MEF must do to carry out this procedure. And they say, similarly, the Supreme Decree must contain a procedure intended to quantify the debt in each case, according to the method adopted for this purpose by the tribunal. And it must be completed within 2 years, and this procedure must show the updated amount of the land reform debt bonds plus the interest, And so if you have updating as a concept, because that's what current value is about, that's the updating part. That's the piece about converting to US dollars and then applying, in this case, a treasury rate, which the ministry chose a short-term 1-year US treasury rate, as you know, but plus the interest. Now, if that was at all ambiguous.
No, we just want to, what about the parity exchange rate?
Yes, they do reference the parity exchange rate in, here, I don't think it's, if I recall correctly, it's not in that paragraph 25. 25 is the methods we're selecting. I think what you must do to find out that is look at the prior paragraph 24, That's the method that they're basically adopting. They say we have the method that proposes the calculation of the updated value of the bonds by indexing existing obligations to their equivalent in foreign currency, which may be the dollar or others, to which the interest rate of American Treasury bonds would be applied. This formula updates the obligation by converting the debt principal to US dollars using the parity exchange rate. So that was and it's very clear, so they're describing that, and that's in distinction to option one, which was an original kind of dollarization approach that they'd studied in the 2004 opinion. So they specify, so that the parameters that come out of the CT 2013 decision are convert to US dollars at the date of default using a parity exchange rate rather than some other kind of exchange rate. And then they instruct the MEF to develop a process to do the updating, show the value of the updating plus the interest.
Very good. Thank you. Let me get now the Republic, the respondent, if they agree that this is what the Constitutional Court decision said. Mr. Now I have lost you because I have, yes, Mr. Hamilton, now I have you.
Thank you very much, Mr. President.
Do you agree with the position of claimant?
I am cautious to say that ever in this particular proceeding, but let me simply answer your question, Mr. President, and thank you for the question regarding principal and interest as addressed in the 2013 court ruling. Keep in mind, members of the tribunal, that the 2001 sentence, a limited ruling, did not set out a rule for valuation method for principal or interest, and did not set out a payment procedure. And those uncertainties were clearly identified by the court in the resolution, and then correspondingly, the court proceeded to establish a valuation method and establish a payment procedure. With respect to the valuation method, the court decision indeed at paragraph 25 and 2425 sets out payment through dollarization updated from the last clipped coupon and interest at the US T-bill rate. I reference you to respondents' closing statement slides 58 to 60 with respect to these issues, to 61. And here we see the language just acknowledged by claimant with respect to the designation of principal paid in dollars.
Very good. So I think there is, we can all, I think, agree that the system declared constitutional by the Constitutional Court was based, as you said, that the principal was converted at the parity exchange rate into dollars on the date of default, then that thereafter there would be interest accruing at the treasury rate of the US treasury rate, and that this would be the system of converting the original debt into current value. Very good. Now let us go to the next step, which is the two supreme decrees, because we have spoken very little about them, and the tribunal, with the tribunal, the three supreme decrees, and the tribunal would like to have some further information on that. Now, I understand that claimant is saying that the supreme decrees are arbitrary, or they are in some way discriminatory, and can we ask claimant to express exactly why it is of that opinion, and then we will get the opinion of the Republic on exactly the same question. Mr. Friedman.
Yes, the discrimination.
Financially, can we focus on these issues which we have now identified? You remember, we identified the principle, the interest, how it was going to be calculated. I know that you have some procedural issues with the Supreme decrees, but can we go to the merits of the Supreme decrees? Why you think that these decrees in establishing the parity rate and in converting to and from dollars to local currency, why, in your opinion, there is some arbitrariness or discriminatory character in these decrees?
Mm-hmm. We addressed that at some length yesterday, so I don't want to repeat everything I said yesterday or the slides. I will give you the highest level summary perhaps, and then if you have further questions. Before I do, I just want to make clear that because I didn't want it to be ambiguous in response to the last question and answer, that what we say the CT required in 2013 was that they do an updating, and that used US Treasury, the interest rate of US Treasury bonds to do the updating. But in addition to that, they needed to add the compensatory interest. So the word interest kind of comes up has two connotations in that. And that's what the Supreme Court, your restatement at the end of what the parties had sort of agreed, I don't think reflected what we believed we had stated to you. So
okay, so the compensatory interest, why don't you dwell on that?
Yes, well, that's exactly what was at issue in all of those Supreme Court cases, including the one that the tribunal asked about in Procedural Order 11. In those cases, the Peruvian Supreme Court said it's not enough to do the updating, which of course includes updating using US Treasury rate, the interest rates on US Treasury bonds. You also, and the Constitutional Tribunal in 2013 also required adding to that compensatory interest on the bonds at the face rate of the bonds, either 4, 5, or 6%. And that's in RA 394, which is one of those Supreme Court opinions, but there are 5 of them. And you recall respondents expert Dr. Hunskoff confirmed that they all said the same thing, that they were intellectually coherent under Peruvian law, and they carried out what the CT, the Constitutional Tribunal, had said in July 2013. So I just don't want the word interest, I just don't want to omit this important element of compensatory interest. And I say that—
How is exactly your idea that this compensatory interest would be calculated?
In general, so just sort of speaking about it conceptually, quite straightforwardly, you add the compensatory interest on the updated value of the bonds. Technically, Professor Edwards showed how you do that calculation in the formula that we attached to the post-hearing brief.
Of course, but Professor Edwards goes to the 762, I think, rate, or
No. I'm sorry, forgive me, but that's, yes, Professor Edwards did calculate the 7.2% rate as a real rate of return on debt in Peru. But put that completely aside, pretend that doesn't even exist. Professor Edwards also shows that if you simply apply compensatory interest at the bond face rates to Gramercy's bonds.
I must interrupt you. We have some difficulty with Mr. Dreimer, who seems to have lost his connection. He's frozen. Can I get the secretary, sorry for that. Can I get the secretary to double check what is happening with Mr. Dreimer?
Mr. President, Mr. Dreimer can hear us. He can just not see us, but we are checking with the technician at this moment.
Mr. Dreimer, you are there and you are hearing us.
Maybe not anymore.
He's on mute, but we can actually see that his mouth is moving and he seems to be affirming that. But Mr. Dreimer, if you came off mute, maybe.
Yeah.
He was saying, wait 1 second. I'm
Okay. I can see it.
interpreting
I
rudimentary sign language.
No, he's frozen. I mean, you can see me well, Mr. Friedman?
Yes, we can see you just fine. And Mr. Dreimer, for that matter.
We are able to see Mr. Dreimer as well without difficulty. He's alive and well
on my screen
and living in Canada.
Mr. Dreimer, if you continue to have problems, I'd perhaps suggest quickly logging off and then logging back on. That tends to quickly resolve the solution.
That is a recommendation for Mr. Dreimer, correct?
Indeed, yes, indeed. That should sort it out quickly, thank you. And we will wait for you here, indeed. Thank you.
You are back. Do you hear us now? You are on mute. I think we have Mr. Dreimer back with us. No, he's dropping off.
He was there, and now
I believe he's just going to do a quick log back in. He should be with us very shortly.
It sometimes also happens to my system sometimes.
Mr. Dreimer is just reconnecting now. He should be with us shortly.
Excellent, thank you.
Thank you.
Right, my apologies.
It happens to me very frequently.
You know what? I lost control. I could hear everything that was being said, but I lost all control. I hope, Mr. Friedman, that your lip reading skills aren't perfect, because some of what I was saying was not fit for public consumption.
Very good.
Thank you,
Mr. Friedman. Why don't you continue?
Yes.
Again, I assure you, I heard everything that was being said, even if I couldn't see the video, up until the moment the technician asked me to log off, which I did.
Okay, so you just can continue where you stopped.
Okay. Thank you. I just want to be quite clear, and it's a response also to the question, Mr. President, that you asked, which is essentially what's wrong with the Supreme decrees. One of the big things that's wrong with them is that they don't pay compensatory interest. Now, the compensatory interest is on top of the updating. That's a conceptual matter, because updating is obviously restoring the original purchasing power of the principal. That's the whole point of it. And compensatory interest is intended to compensate people for the time, the value of money, the time that they didn't have that principal to be able to use. And that's what Professor Castillo and Dr. Hunskoff agreed on. We say it's what's in the 2013 Supreme Decree, the 2013 Constitutional Tribunal decision in paragraph 28, when they said the ministry has to show the updated amount plus the interest. We say that's confirmed in a 2015 CT decision. But even if you don't believe either of those, the Peruvian Supreme Court addressed that issue 5 times, including in that case, RA 394. And at paragraph 10.3 of that decision, they clearly state that because the Article 1242 of the Civil Code establishes that when interest is compensatory, it must be paid. And they say in this legal context, it is observed from the land reform bond coupons that the parties agreed that compensatory interest would be at the rate of 5% per annum or 4% per annum, depending on the class of bonds, obviously at issue in that case. And then they said, accordingly, it was appropriate to order that said compensatory interest be paid once the debt had been updated and the judgment enforced. And they reversed the lower court for not having included that amount, that compensatory interest amount, on top of the updated value of the bonds. So as we described yesterday, one big problem in the Supreme Decree process is there's simply no recognition of this and no inclusion of it. We also had a sort of conceptual problem that they didn't even attempt to do the balancing of it, the balancing that the Constitutional Tribunal had required. I think we mentioned that point yesterday, that there had to be, you couldn't prioritize state budget on the one end or paying the bondholders on the other, but you needed to have a serious number, which we say they didn't accomplish. And so in addition to, but you were asking, Mr. President, about the sort of technical or computational questions. And so I want to confine the rest of my remarks in response to your question on that. In addition to the lack of compensatory interest altogether, there's also the use of the parity exchange rate.
Yes, and I would like you to explain that to us.
Yeah, we explained yesterday, and I hope through the testimony at the hearing, why the parity exchange rate is arbitrary in the sense that it has no logical justification in any of the decrees, and why it is a very unusual, and even in the August 2017 decree, an incorrect way, simply like economically irrational way of calculating a parity exchange rate. And as I explained yesterday, but really it's Dr. Edwards who explained this, that if you're looking for a parity exchange rate, what you're trying to do is find a time.
I perfectly remember the argument. So the next, I just want that you itemize to me. So you say then the parity exchange rate is irrational. Are there other elements which are irrational? Because I seem to remember that you said the parity exchange rate and then the return rate was different. And I just want to get the financial aspects which you think are irrational and lead to an irrational consequence.
Okay, so it's one, lack of compensatory interest, two, parity exchange rate, which is irrational. And there are really then two branches of that, because there's sort of two ways that you could fix that essentially. One is by using a real parity exchange rate, like one that was calculated in a responsible, economically rational manner. And Professor Edwards gave you one of those. Or as a sort of cruder fix, if you will, just use the irrational parity exchange rate, both to convert to US dollars, and then after the updating process is done, when you convert back to soles. Because at least then you would be using this kind of broken measure, but you'd be using it consistently, so it wouldn't, the fact that it understates value in one direction would overstate it coming back and would, in a sense, compensate. It's not as intellectually elegant, I have to say, as just using a responsible parity exchange rate in the first place. But both of those solutions respond to this point about the irrationality and arbitrariness of the parity exchange rate. And then three, there's a third component of it. It has a slightly different character for a reason I just want to be very clear about what our submissions are. But the updating from the date of last clip coupon, basically, instead of from the date of the date that the bonds were placed.
But that we all agree was mandated by the Constitutional Court.
That's exactly
So-
why I say it's something of a different character. We do think that it's quite irrational. That's the Professor Castillo's testimony about the solar eclipse. It doesn't make sense when the idea is to restore the principal to its original purchasing power. But that said, that's why I flagged it up specifically as having a different character, because that was, in a sense, part of the Constitutional Tribunal 2013 order.
Very good.
And for further reference on this, I'm just trying to be very brief, but you could look at our post-hearing brief, section 2C1 and slide 70. Sorry, let me do that again. Section 2C1 and the closing slides from our presentation yesterday, slides 70 to 81.
Thank you. No, to be true, I mean, we probably could get the answer to all of these questions going through the record, which is extremely detailed. It is just that we wanted to get some clarified summary from the party, so that we can, in our minds, exactly see the opposite positions. With that, I give Mr. Hamilton the floor.
Thank you very much, Mr. President and members of the tribunal. I will share comments, and my partner, Dr. Llano, will share some additional observations as well on this issue. And as a starting point, we left off with the prior question with the provisions of the 2013 Constitutional Tribunal sentence, which finally brought clarity to issues of valuation and procedure. And what we then see with the development of the Supreme decrees is a process that implemented the court ruling. And I just want to underscore, before we now dive into this particular issue, that these decrees were developed through extensive documentation that included, for example,
Mr. Hamilton, sorry to interrupt you. In the interest of time, we are perfectly aware. Let's go to these four. We are really interested about the financial
We're
aspect.
coming. We're coming. We're
So
coming.
let's go to, if you are kind enough, let's go specifically to the issues which have been flagged by claimants.
That's where we're headed, Mr. President. Thank you very much. But I do want to underscore that whereas Gramercy continues inventing different arguments even until its final brief before the tribunal, these issues were addressed in internal records, external expert reports, all in the record of the development of the decrees, and all addressed by Mr. Kaczmarek with respect to the manner in which the decrees carry out appropriately the court decision. And I direct your attention to Mr. Kaczmarek's presentation from the hearing at slides 22, 28, and 38. Now, with respect to the two issues that we were just discussing, let me first mention the parity exchange rate. Peru has established that the parity exchange rate was not mandated. And during the hearing, Mr. Edwards himself confirmed that it's difficult to choose the base that you have to apply. And when you do, it is complex. Mr. Edward used ex post facto information, as we have discussed in our prior pleadings. So Gramercy's criticism of the parity exchange rate used by Peru is also inconsistent with its own position. In particular, Gramercy alleged that Peru's use of January 1969, a single month, as the base period contravenes what they call a basic rule. And Gramercy self-entitles itself to create all sorts of supposed basic rules or certainty that simply are not applicable and are not supported. In addition, regarding your query as to compensatory interest, Gramercy applies the bond's stated coupon rates on top of the U.S. Treasury rate. And in its post-hearing brief, Gramercy claims that the addition of compensatory interest is somehow required by what it calls clear and well-established principles. That is simply, again, not the case. And it is belied by its own expert, again, who did not include compensatory interest in the manner of that Mr. Edwards prepared his initial calculations in his first and second reports. Now, I want to invite Mr. Llano for additional comments in this regard.
May I ask just, pardon me, Mr. President and Council, may I ask one question following up directly on Mr. Hamilton's last couple of words? And perhaps I've misunderstood. It's probably the case, sir. So clear things up for me. In Peru's view, did the 2013 Constitutional Tribunal resolution mandate compensatory interest on top of updating of principal by whichever means?
I'd be happy to take that question.
Sure, absolutely. And perhaps you are coming to it.
I was going to start with that, Mr. Dreimer. Thank you very much for the question. It really does tee up the point. So I'm looking at the 2013 resolution, and I would direct your attention to paragraph 28. The last sentence of paragraph 28, and I apologize, I have the Spanish version in front of me. It says that it mandates that the procedure that will be established for payment of the bonds, quote, must provide the amount of the actualized value of the bonds of the agrarian debt plus interest. Okay, so here are the two components that the court directed to the executive, and in particular to the MEF. It's the actualization, the updating, and interest. The first component is achieved through dollarization. The updating of the value of the principal is converted to dollars. And it's not just me saying that. I would direct your attention now to paragraph 24 of the resolution, which says that the actualization in the first sentence, there we are. It says the methodology for the actualization of the bonds through the indexing of the existing obligations to their equivalent in foreign currency, which may be dollar or any other of free circulation, to which the interest rate of the American Treasury bonds will be added. So there again, you have the two components. Actualization is achieved through dollarization. Interest is achieved through the T-bills. And we know that because it is, I think, a common ground between the parties that T-bills include an interest component. And so, of course, this general formula or general framework that is being set up here leaves some issues that must be filled out, which the MEF did in a very rational way, and which is not for us, any of us, to micromanage at this point. The question being, for example, what is the proper parity exchange rate to convert to dollars? The first element of the formula, actualization through conversion to dollars, must be done through a parity exchange rate. The MEF applied the January 1969 rate as the parity exchange rate. And that makes sense. That makes total rational sense, as Mr. Kaczmarek explained, because the information that came after the stoppage of payments on the bonds was exposed. It wouldn't have been known at the time of the non-payment, which is presumably the issue that we're trying to fix here. With respect to the T-bills, why 1-year T-bills as opposed to other durations? There are all sorts of reasons for that. Long bond durations carry more risk, and Mr. Edwards admitted as much on the stand. And you can do a search for the phrase long bonds in the transcript, you'll find it. There were a couple of exchanges on this, and he said, yes, it the longer the hold, the longer the risk, the bigger the risk.
I think we all understand that.
Right. It's a very basic concept. And so you have these, again, just going back to, first principles. You have actualization through dollarization, done, check. That was done through the conversion to dollars at the parity exchange rate selected by the MEF. Then you have the T-bills, check. The MEF selected the one-year T-bills, which made total rational sense. And then you have this red herring about, do we add interest on top of interest? And the answer is no, for legal and economic reasons. From a legal standpoint, the 2013 resolution does not require interest on interest. It never says that. And I've shown you the two paragraphs, 24 and 28, which reference the issue of interest. Again, dollarization plus interest, not dollarization plus interest plus bonus compensatory interest. That's from a legal standpoint. From an economic standpoint, I would direct you to Mr. Kaczmarek's testimony during the February hearing, seems like ages ago, where he explained that that would be double counting. To apply the T-bill rate plus some other compensatory rate, whether it's a stated coupon rate or whatever else, is double counting for interest. But that is precisely why the two last alternatives which Gramercy has provided, which belatedly came with their post-hearing brief, are completely wrong because they do just that.
Mr. Llano.
Okay.
Dr. Llano. Thank
Fine.
you. Thank you. Okay. I think you are getting now into pleading your case, and thank you for your explanations. I think this is now reasonably clear where the differences lie. Let me
Mr.
then,
President, may I respond?
of course, if you want, if it's short and on these points, I kindly ask you that we really address these issues. But if it is on these financial issues, you are more than welcome.
Thank you. It is exactly on these same financial issues, and responding specifically to what Mr. Llano just said. First, I think that it's intellectually and wrong and legally wrong to suggest, as he did, that merely converting to US dollars is updating the debt. All that would do is establish a value in US dollars at some historical point in time, could be 1972. That's not the value today. At the very least, that number would be subject to inflation risk in the United States. So that can't be the updated value of the debt. Second, as you know, that the interest rate, as we pointed out, in the US Treasuries, especially the short-term ones that the ministry chose, is immaterial. It's not the same thing as the compensatory interest in Peru, the Peruvian law and the civil code requires. And third, please don't take my word for it, but the Supreme Court 5 times on this very issue, which the respondent continues to avoid addressing in all of its responses. And last, I simply want to suggest that this idea that there's something wrong with using ex post data, that none of the data that you needed to responsibly calculate a parity exchange rate was ex post or unavailable in 2013 or 2014. I mean, there were plenty of years of parity to use as reference at that time. It wasn't like the MEF was establishing a parity exchange rate in 1969. And while I quite agree that it's not the tribunal's job to just sit and second guess on economic decisions, it is the tribunal's job to analyze state action that's consequential against the legal standard which prohibits arbitrary and irrational decision making on important investor rights. So if that's the level, I would just suggest that you take, that is obviously your job. And as between Mr. Kaczmarek and Professor Edwards in evaluating how you think about what's rational or not, or the rules of calculating parity exchange rates, Professor Edwards has published books on it, and Mr. Kaczmarek said he doesn't deal with it. It's not something he spends time thinking about. Thank you.
Thank you. So,
Mr. President, can I make a 30-second economic rebuttal?
Yes, but we'll get then. Let me close the door. And
Mr. Llano, you can make more than 30 seconds because we just heard more than 30 seconds.
To say, but then I have, okay, hopefully this is the last argument on this topic, because we have a couple of others.
Okay. So of course the MEF has actualized the debt. Don't forget, Mr. President and members of the tribunal, that in 1992, when the Agrarian Bank closed, the Gramercy held bonds were worth 34 cents. So the fact that they were converted to dollars is not, again, not me saying it, and I appreciate Mr. Friedman's words, but take a look at paragraph 24 of the decision. It says actualization through the indexation to dollars. That is the mechanism that the court directed the MEF to use. And they did. 34 cents were converted to more than $3 million, $3.3 million. That's a 900 million% hair extension. So that is certainly an actualization to current value. And on top of that, there is interest through the application of T-bills. So mission accomplished. Thank you.
Very good. I think the discussion is clear. Let me get to another point which is related. And that is the 33.57 million US dollars, which respondent says that claimant would receive if it's submitted to the bond exchange, the bond payment procedure. Now, first of all, I have a couple of questions. The first one is, where does this figure come from? Is this a figure from respondent? Because respondent, when you refer to it, you just then refer to statements by witnesses of claimant. But I am not clear, and that is in page 35, note 276. The origin of the 33.57 million US dollar figures are the two, Mr. Edward and Mr. Königsberger. Where does this very precise figure come from? And I think I should ask first respondent. Dr. Llano, maybe you or Mr. Hamilton, whatever is more convenient.
Thank you, Mr. President. This number is derived from an examination of the purchase contracts which Gramercy withheld from this tribunal for an extended period of time. Mr. Kaczmarek, in the initial quantum expert report by Peru, took available bond purchase contracts, calculated those amounts, and reached a total of approximately $33 million. Then Gramercy, the cat being out of the bag, that it was asking for at that time $1.9 billion, then did the calculation itself, and itself acknowledged in pleadings and reports and at hearing that the figure had been $33.57 million. And so this figure is derived from the bond purchase contracts. And obviously I will not enter into the issue about where the money came from, et cetera.
No, so it is, let me understand it, this comes from Mr. Kaczmarek. So there is a representation by the Republic that this is the amount which claimant would receive if it presented its bonds to this system.
No, Mr. President, perhaps I can clarify. There's two different figures. One is the amount that was used to acquire
I know.
And the second is what they would.
I know the facts of the case extremely well. No, sorry
but what I've answered so far.
Let me explain to you exactly what I'm. The
Sure.
33.57 million figure, which you round up to 34 million, is in your post-hearing brief, page 35, last bullet of paragraph 76. And it is, you say, Gramercy could have obtained US dollars 34 million. Gramercy's witnesses confirmed the undisputed fact that Gramercy could have obtained US dollars 34 million if it had tendered the bonds into the bondholder process. And this is what I was asking you. And you have, I think, clarified to me that the number comes from Mr. Kaczmarek, and you are now going to confirm to me that this is a representation by the Republic that if the bonds are tendered, this is the amount they would receive under the bond payment program.
Thank you, Mr. President. Your question is now more clear to me. So just to confirm, my prior comments related to the calculation of the amount paid to acquire the bonds. If you turn to the separate issue, and there is a coincidence now, it was a process that the parties are aligned as to what was paid to acquire the bonds. Similarly, there is a coincidence of calculation by the experts on each side, applying the bondholder, the formula of the Supreme decrees, what amount would Gramercy have received if it participated in the process. Gramercy itself stated in its third amended notice of arbitration and statement of claim from July 2018, Gramercy would receive 33.57 million. So that exact figure, Gramercy states that in paragraph 3 of its principal brief of July 13, 2018. So what I would say at this point is that Gramercy repudiated and disparaged the bondholder process. It never participated, so it never went through a valuation process like participating bondholders. In the context of this arbitration, respondents, quantum expert, and Gramercy itself have effectively aligned. I don't know if there's a slight difference, but have effectively aligned that the amount available through the bondholder process would be in that range of $33.5 to $34 million, applying the formula of the Supreme decrees. That is the position of respondents expert, and that obviously assumes that all of the bonds are authentic.
Of course. And then I understood, I think this was the first time I had that understanding from Ms. Menaker, that these 34 million would not be paid in cash, that they would be paid in bonds, in normal financial bonds issued by the Republic. And first question, is this correct?
The Supreme decrees provide for payment options. One of those payment options is to receive new bonds. As set out in Peru's closing statement today, Gramercy has indicated, and it's a matter of record, that it was interested in receiving new bonds. And I refer you to comments that I made earlier today in that regard.
Yeah, because I understood Ms. Menaker to say the following. Because you remember that one of the decree has this payment schedule. And the last one to collect is tenedor especulativo, speculative holder of debt. And I don't know if it is clear whether Gramercy would or not fit into that category. And if it were to fit into that category, I now understand after Ms. Menaker's statement that it implies not that it does not collect, it implies that it does not collect in cash, that it cannot collect in cash, that it must collect in bonds. And so it would receive the 34 millions in bonds, presumably in bonds which have a market value equivalent to 34 million. Could you clarify that, Mr. Hamilton?
Yes, Mr. President. The Supreme decrees establish a menu of options for payment. That was one of the things that the initial decree anticipated, that as the process went forward, they would finalize the payment options and verify the formula, which is exactly what they did. And there is a menu of options, and that menu includes electing to receive payment through new bonds. And that in the past has been what Gramercy has expressed an interest in. There certainly is not a provision that says Gramercy doesn't get paid. And of course, I think it goes without saying, the principal reason Gramercy hasn't been paid through the bondholder process is because it did not participate, because they process the bonds presented into the bondholder process, just like when you go and buy ice cream. The first one in line is the first one that's getting processed through.
But you have not answered my question. Is Gramercy un tenedor especulativo? And what, if it is, what is the implication?
Well, I believe your question was whether Gramercy would not get paid because it potentially could be designated that way. And the answer, as Ms. Miniker set out, is that Gramercy can be paid through new bonds or other options in that list. Now, there are limits on cash outlays contemplated in the Supreme decrees, and that is the way that the ministry reasonably regulates the risk of the uncertainty of not knowing how many bonds are out there.
Let me phrase your statement in my terms. It is your representation on behalf of the Republic that even if claimant is considered as a tenedor especulativo, that would not affect its right to receive $34 million in exchange for the bonds, to be paid not in cash, but in Peruvian normally traded bonds for a value equivalent to $34 million.
I'm just reading the transcript again to be confident in my reading of your question.
Of course. What is missing, what Don is missing is, in Spanish, is speculative holder. I think in these brackets and two stars, this is of course of the record, Don. To improve the transcript, we should change further up where it says, as in Spanish, the easiest way of solving that blank in the transcript is to put in speculative holder.
Yes. Mr. President, regardless of whether Gramercy were considered to be through the bondholder process, if it were considered to be speculative, as you mentioned, that would not prevent Gramercy from receiving compensation through election to receive new bonds. And the amount, as we have discussed, there is a coincidence of opinions by experts in this proceeding that the amount available by applying the formula of the MEF would be approximately $34 million.
And now I give, yes, Mr. Drani.
I apologize. I still don't understand. And again, it's probably just me. I understood Ms. Miniker to be telling us that ranking, if you will, that puts speculative holders at the bottom applies only to those who request payment in cash. And then she further said that my understanding is that they can only request $30,000 in any event. So it's immaterial in this case. Did I understand correctly? In other words,
yes, Mr. Dreimer, thank you for your question and confirmation. And I invite Ms. Miniker to join. We are not in the same location, and so we can't signal to each other. But yes, precisely. And if you look at the text of the Texto Único Ordenada from August of 2017, you can see this is confirmed.
And again, conversely, that ranking, if you will, that places speculative holders at the bottom does not apply to holders of agrarian bonds who seek payment for them in the current process by means of issuance of current Peruvian bonds, correct? It applies only to people who ask for cash. It doesn't apply to payment in the form of bonds.
Well, I think the critical point, and here's Ms. Miniker, I'll let her comment on this, but I think part of the critical point is that it's effectively immaterial to the reality of what would occur here. Ms. Miniker.
I'd like to say that yes, that is my understanding, and I was hoping to get the document from a colleague, but
all right.
Of course, we're not in the same location. But yes, that it doesn't affect their right to compensation through this procedure. They would still have the 34 million, however, not be paid necessarily in cash, but again, only up to that small amount. That is what it is. It's priority ranking for these cash amounts.
That's what I happen to have understood your argument to be earlier on. Thank you for clarifying that. You, Ms. Miniker, and Mr. Hamilton.
So now let us see if Mr. Friedman has any further question. Not further question, but further comment to this question. Sorry.
Yes. There are so that colloquy involved a few issues. If I may, I'd like to briefly address each of them. The first was, where did the calculation of the notional amount that the bondholder process might offer to Gramercy come from? I think I can help bring some clarity to that question of the tribunal. I believe that that was first calculated by Professor Edwards, and you'll find that number in paragraph 271 of his amended expert report, which is CER 4. That was based just on him trying to apply the formula as he best understood it. I have to say that we also have been confused about whether Peru has ever actually subscribed to that number. It's usually been put, this is something they say they could get, instead of something that we adopt. It may be that Mr. Kaczmarek calculated the same number or confirmed that in his first quantum report, but I have to say, I'm not, to this day, I still don't know whether Peru has actually ever said that or represented that that was their understanding of what their own decree would yield if applied to all of Gramercy's bonds, assuming, of course, that they were authentic and whatever other filters they put them through. But I don't know that that is their representation. That's something we calculated to try to parameterize what it could be, but that's all that it is as far as I know. Second, you asked about the treatment of speculative holders. I think, well, you'll make what you will, of course, of the responses you've had to the direct questions today. And of course, you heard the witnesses testify about whether that's a Gramercy bill of attainder, basically, or not. And so I think we've submitted the evidence on that. But I don't think that the representation and that alone, even if it did only apply to the cash payments, it would still be discrimination. And we think emblematic of a lot of the thinking behind these. We think that it stands for more than it would be in that case. But I don't think we accept the idea that it's limited to cash payment. It's true that the bondholder process does say that cash payments can only be made in an amount up to 100,000 soles, which is about 33,000 US dollars at kind of normalized exchange rates for any bondholder, right? That's what it says. But then the payment priorities are not distinctly linked or limited only to the payment in cash. And it's true that Gramercy has said on a number of occasions that it would be happy to accept bonds as part of a global settlement, because that could be a good way of restructuring that would spread out Peru's obligations over time. But I have to say, Gramercy always would have been happy to receive cash, and much more happy to receive cash than more bonds. And I have to say the other thing is that, you know, it's fine to talk about bonds, but if you actually look at the payment provisions of the Supreme decrees, not only is the waterfall not necessarily limited to cash, but the flexibility of the ministry in how to pay the debt, what forms to pay in, other than the cap on cash, are wide open. They can pay in land if they want to. They can pay in bonds, but it doesn't specify what bonds. One of the earlier proposals, the 2004 proposal from the regulation from the government, which was itself a Supreme decree, that the Constitutional Tribunal studied in that 2004 decision. Remember the optional dollarization one? That was interesting because that Supreme decree had a very high interest rate on top of the dollarization. It added 7.5% interest to dollarization. But the problem with it was, and the reason bondholders didn't take it up, was that it said, we're going to pay you in bonds that pay no interest for another 20 years. And there's nothing that prohibits the ministry under the Supreme decree from paying with a bond that has some face value or however they determine it, but that it doesn't have valid economic value over time. So there's an enormous amount of, I just want it to be very clear that there's an enormous amount of discretion that the ministry has reserved to itself in how it actually goes about paying bondholders. Of course, in the event where it's only paid about $300,000 in cash to all bondholders who went through the process, at least up to the last time we saw evidence on it, I don't think they had to make a lot of hard decisions. But they also reserved themselves to stop making payments if it's going to hurt the budget of the country. And so there's quite a lot in there that's unregulated and very uncertain for any bondholder who goes into it, especially since you have to waive your rights to do anything else once you submit to the process.
Mr. President, we are unable to hear you. Thank you.
Sorry for that. No, I was going to say, if you want to comment on this argument by Mr. Friedman, that a holder of land bonds would have to waive his right to collect through the courts or through any other system before embarking in this Supreme decree procedure, and that there was a wide margin of discretionality for the Ministry of Finance in how the payment can be structured. And Mr. Friedman was saying it could be structured in a 20-year bond without interest, and that this created this lack of knowledge compared with the necessity of waiving your rights, that it created, I don't know what your what the adjective was. I don't know if you said arbitrary or discriminatory, or what was exactly the adjective you used to qualify this tension.
Mr. President, I will comment, and then Ms. Miniker will comment as well. I will comment to clean things up, because Gramercy continues to be all over the map, because of course in imaginary land they can make up all sorts of things that they think would be nice for them, but that's not the way this works. This is not a restructuring, it's not an offer, it's not a negotiation, it is the implementation by a sovereign of the ruling of its constitutional tribunal as carried out appropriately through Supreme decrees. And so specifically with respect to the issue that you raised, let's be clear. There is a common understanding before the tribunal by the parties and their experts in this arbitration that Gramercy paid 33 million, Gramercy could obtain 34 million. Of course, the ministry has not opined through that process. I must say it because we just heard confusion. The ministry does not opine on bondholders who are not participating in the process. So we have articulated there's a common position. 33 paid, 34 million approximately available for authenticated bonds. With respect
but that
to
was not my question, Mr. Hamilton. Sorry, that is not the question. The question which Mr. Friedman raised, I would like your comments on, is slightly different. It is that you have to embark without knowing the outcome. And I just, that was the argument of Mr. Friedman. And could I get your comment on that?
My one final comment, and then we answer your question. And I'm sorry, because we heard confusion that could clutter understandings, and therefore I'm simply cleaning up the basics. Second, I refer the tribunal to Article 18 of the text from August of 2017, which specifies, and I'll read this in Spanish, if I might, la prelación en el pago de la deuda actualizada de los bonos de la reforma agraria se aplica únicamente a la opción de pago en efectivo. That's to finish addressing the priority question, which there continues to be, it's expressed and it's clear. Now, the other issue, Mr. President, which we now come to, having confirmed the foregoing, Ms. Miniker, again, we're not in the same room. Is this what you're interested in proceeding to address? Perfect. Thank you.
That's a leading question, Mr. Hamilton.
She's waiting patiently, so I'm going to bend to her will.
You know, it is difficult in these times where we are all separated in organizing answers to questions when you have a big team. So thank you for both parties for their efforts in doing this this hearing in this fashion. And we are perfectly aware that it puts strain on everyone. So if anytime any of you need some time to collect or you would like some time to speak to all of the members of your teams, please feel free to say so. Ms. Menaker.
Thank you. So just in response to your question or the comment that whether there is a problem because you needed to waive your right to pursue court action, for instance, without knowing the specifics of what would occur. And Dr. Wooler actually addressed this in both of his expert reports and remarked that it's not at all an unusual feature of mass claims resolution procedures, that when you have these types of commissions put forth that are established by a state to resolve mass claims, often exclusivity is a primary factor or element of that, because otherwise the system doesn't work, right? I mean, if the state is going to essentially create a system and they want to do it, put everyone on the same footing, apply the same types of considerations, and then have, you know, a certain amount of money or something like that they're going to pay. It only works if you funnel everyone through that type of system. So it's a very common element, and that's what Peru did here. So that doesn't, in our view, make it at all arbitrary or irrational, and certainly it's not unusual.
No, I think if I can just, I completely understand that you have to get everyone on the same line. No, I think Mr. Friedman was saying that the outcome, that there was a high level of discretion. And I think you could be paid with land, for example, so that Gramercy could find itself to be the landowner of some land in Peru, or that you could be paid with a 20-year zero coupon bond. Could you just comment on this?
Yeah, no, I think that is just not reasonable interpretation of the decrees, because what the state has done is it has afforded itself some flexibility, because as we've discussed, I mean, you have this mass claim procedure. The state has a public interest in ensuring that it's going to be able to balance the public objectives, maintain fiscal stability, et cetera. So it has to guard against an unknown issue, because again, as we've said, they don't know for certain how many of these bonds are outstanding and what the potential liability might be, because there was no register. You don't know if people have been hiding these in their attics or something. So they're not sure of what could be the outcome. And what if they were flooded with tons of claims immediately and they wouldn't be able to satisfy them by like paying out the cash or even paying out bonds that would become due, very quickly. They had to afford themselves some discretion. Now, the amount of compensation is not varied because that's done pursuant to the formula. So even if you get a bond who's like, you're going to be paid later, you're going to still be paid what the compensation is. You're just, the form of payment may change just in order to ensure that the state has the fiscal wherewithal in order to cover its liabilities in that regard. And I think that when looking at this in context, I think that Gramercy is really, making it seem as if it is much more not problematic, but uncertain. Like, to say that they would be afforded land just doesn't make any sense, right? I mean, that naturally would be put in because this was all due to the expropriation of land. So again, the state is putting something in there to give itself a little bit of flexibility that in the event a landowner came in 50 years later and said, my land was expropriated, okay, here's what it's worth, maybe maybe we can just do that. That might be easier. Are they going to give Gramercy land? I mean, no. And if they did, it would still be worth that $34 million and they could go sell the land. I mean, it's still, but I just think that's fanciful thinking, that would actually apply to them. And so I think, again, the state has afforded itself some flexibility to make these payments in different ways in order to ensure that they always had the fiscal stability to run the country, and that it also, there's tension in Gramercy's arguments that this alleged uncertainty prevented them from going into this process, when at the same time they remark that participation rates were so low. Because if participation rates were as low as they say they are, then it wouldn't have put that strain on the fiscal capabilities of the government, and the government would be able to pay in the ordinary manner.
Mr. President and Ms. Miniker, please, just to provide a citation, and let's be very clear here. The decree states at Article 16, modalities of payment. And it says specifically, and I'm going to read it in Spanish, los tenedores legítimos de los bonos de la deuda agraria con deuda actualizada pueden optar por los siguientes modalidades de pago. A, pagos con bonos soberanos. B, pago con la entrega de tierras. C, pago en efectivo hasta por la suma máxima de X. D, por mediante canje por inversión en los sectores priorizados por el Estado. This is a menu. The reason that I keep saying menu is because it's a menu to the bondholders.
Mr. Hamilton, pardon me, sir. When you switch back to English, I missed what you said. If you can just start after your Spanish, please.
No problem. Going back to English. The reason we're referring to a menu is because in black and white, there's a menu available. And I just read the menu to you. And the menu starts with bonos soberanos, with sovereign bonds, and has the other options as well. And those are the options made available. That menu is made available to legitimate bondholders, not differentiating again among them at all. And as I just cited earlier, the same decree also makes it clear that the issue of prioritization only relates to the payment in cash, and the payment in cash amount is strictly limited, therefore immaterial. Finally, your initial question, Mr. President, about the requirement of a waiver, in addition to all of the important arguments that Ms. Miniker made, it's also notable that there was a similar requirement under some of the draft bills that Gramercy supported and were never passed. Thank you.
Mr. Friedman, your last words.
Yes, I will be brief. I'm quite glad that Mr. Hamilton brought you to the text of the MEF's own regulations. They did change a little bit also between 2014 and 2017. So he was reading to you from the 2017 ones, but I'm glad he did. The reference is CE 275, Article 16. And I mean, what it said is he read it accurately. There's a set of options. The option for actually getting paid in cash is limited to 100,000 soles, or about 33,000. And I should just add, just to be fair, what it says is that you can be paid up to that small amount in cash that can be paid where possible over not more than 8 years. So the MEF can also string out payments in cash over 8 years if it wishes to. But then the other 3 options that are left after whatever you have above 100,000 soles are sovereign bonds with no terms specified. And remember, they did in that earlier iteration have no interest bonds with a 20-year term, or investment swaps in sectors prioritized by the state, or land. So really, you can only get $30,000 in actual cash. And the rest of it is up to whatever the MEF really ultimately decides. To the extent, and I think Ms. Laveau explored that also with Dr. Vuhler during his testimony. You might refer back to that. He couldn't really explain it or explain how it would work, but it's quite clear that at the end of the day, the ministry creates those options. It tells you what's available. So if you can choose from 3 really bad options, it's not a particularly good choice. I think, yes, I think that was really the only thing that I wanted to draw to your attention. Thank you.
Thank you. So I think this now brings us to the end of the hearing. Let me double check with Professor Stern and Mr. Dreimer if there is anything else they would like to put to the parties. Professor Stern? No, she's perfect. And Mr. Dreimer?
She's always perfect, even if she has questions. I have no further questions. Thank you.
Very good. So this really then puts an end to the hearing. It puts an end to this extensive case. I thank you all for the double effort you have made in making such excellent presentations. And I know you are spread all over the world, different offices and different places, some in lockdown, some at home. It has been an extremely high quality presentations, extremely helpful. There is a lot of work which went into them on both sides. Just looking at your post-hearing briefs, how much work and how well you have both used the evidence to support your case. This could be law faculty examples to show students how one should draft a post-hearing brief. So really excellent work. We appreciate the effort. And we appreciate the effort of our court reporters and our interpreters. For them, these presentations are always extremely hard work. Thank you for the efforts, and to our technicians. I think they are in England, in fact, at least by the accent. Thank you very much. Except for Mr. Dreimer, whom we missed. It has worked very, very well, but it was probably something not to do with the system, but with Mr. Dreimer. He probably pushed the wrong button. This is off the record, Dawn.
I'm less than perfect.
We lost you, no? Or at least I lost you. It has worked very, very well. Thank you, Marisa, and thank you to the technicians and to all the supporting staff. You are all worried and you would like to know when the award will come out. We will do an effort. It is a complex case. We will have a deliberation tomorrow to start the work, but it will take some months that we just get through the facts and then all the jurisdictional issues, and then if we get there to the merits, we'll keep you updated on how we are progressing. But it will not be, it's a complex case and it will take some time to, you know how much work goes into one. It has gone into all of your presentations. An equivalent amount of work will go into the award, and it takes inevitably some time. So with that, I thank my 2 colleagues and I thank all of you. And I wish you, today is Wednesday. I was going to say, Mr. Hamilton and Mr. Friedman, that you should give the weekend off to all your younger staff so that they can relax after what must have been very hard work. But it's Wednesday, and maybe it's too early for that. But they deserve not to work at least on Friday. So that is to all the young lawyers who have done the really tough work. I think that they deserve at least 2 or 3 days off to recover from their efforts.
Oh, they're getting a holiday next week anyways. It's Thanksgiving, so.
Oh, it is Thanksgiving. Sorry,
keep their
in Europe,
noses
we
to the
never get
grindstone.
these. So when is Thanksgiving? This week or next week?
Next week.
Next week.
Next week. Well, then they should take the
We're
week
taking the
off.
rest
I
of the
mean,
week
don't
off.
even start work after.
I think they can have the month. It's just take the month off. It's fine. So, Mr. President, let me, if I may, just for a moment, I want to, of course, join in and echo all of the thanks that you extended to all of the people on both teams at White and Case, as well as at Debevoise, as well as Estudio Rubio and Estudio Rodrigo, and the people at the clients who worked very hard on sort of making sure that we were able to bring all of this to you, and to all of the people who made this possible, the assistants, the secretariat, thank you, Marissa, the translators and interpreters, but also a special thanks to the three of you. We have given you a lot of material. I know that during the February hearing, with a bit of anxiety about what might be happening in the world in the back of our minds, you nevertheless stayed quite late some nights to make sure that we were able to work through. And you have always been throughout, well, I'm sure both sides had from time to time, wish things had come out maybe a little bit differently. We are grateful to you because we think you've conducted the case in a very responsible, appropriate manner. And we really do wish to thank you for your careful attention to it, which has been obvious throughout, and just for the very professional way that you've handled things throughout. So a sincere thank you from Gramercy and Debevoise.
Thank you. Mr. Hamilton, you don't have to echo that. You can just say, well, I let you also thank you. If you prefer, you can even express whatever you feel at this moment.
Thank you, Mr. President. And of course, we offered empanadas as well. So I think we all can be in a more relaxed frame of mind. I want to mention two things before I say thanks. Number one, and please forgive me, but the order of the menu of options in the Supreme Decree derives from the 2013 court ruling. I refer you to paragraph 29 and the subsequent paragraphs. And also just to confirm, the 2013 court ruling does not provide for accounting from date of default, but rather date of last coupon. Just a factual note to ensure there was no lack of clarity in the record. And the other thing I need to mention,
a factually inaccurate note.
Okay, we'll look it up.
So the other issue is cost submissions.
We will look it up and we will double check. As you know, we always double check every single item, and whatever is there, we will double check it, and it will come out the way it was.
Cost submissions is the other thing I wanted to mention before saying thank you.
Thank you.
And we want guidance and pragmatism, lest we reopen Pandora's box that the president has just managed to close.
Yes, I would propose the following. We now declare the procedure closed, so there will not be any new submissions. There will be no marshalling of evidence, except if there are exceptional circumstances. Should that happen, you both know the rules. You must first write to the tribunal without making the submission and without attaching the evidence, explaining why you have to make that submission or why you have to marshal the evidence. We will hear the other party and we'll take a decision. But you know the rules, and you are highly professional, experienced counsel that no sua sponte presentation of submissions or evidence after this point. So that is the first issue. The second is we need, of course, your input on costs. I would recommend that after Thanksgiving, at some reasonable time after Thanksgiving, on the same date, you make, I would expect an affidavit from Mr. Friedman and Mr. Hamilton, or from Ms. Popova and or Mr. Llano or Mr. Gijón, whoever is, but I would assume Mr. Friedman and Mr. Hamilton, making a breakdown of the costs you have incurred in this case. It may be interesting that you break it down, taking into account jurisdiction and merits and the rest. So, because if we allocate, depending on where we come out in jurisdiction, there may be a different allocation or not. So I would kindly ask you that you break it down in two phases, jurisdiction and merits, and that then you also break it down by stating itemizing the different costs which you have incurred. And I would expect that you state that these are the true and proper costs, and subject that you disagree with this proposal, I think that this is the most efficient way to go about it. But let me ask Mr. Friedman first.
I have one other comment in response to the housekeeping comment that you had made, but if you would, on cost submissions, I think that it may be that the parties should discuss. I think what often comes up is sort of what date do you want them by, and what level of detail are you interested in? And I think it'd be good for us to have something that looks similar, that has the same level of detail, and a date that doesn't require our teams to miss the Thanksgiving holiday in the United States. It
could be, I would say, by the end of November or the middle of December. There is no hurry in it. So before the year end, you should send it, but not before that. And the second is, why don't you establish the date? I expect a 2, 3, 4-page summary, and in the form of an affidavit from one of you, or from both of you, itemizing the costs, maybe starting with costs related to jurisdiction and to the extent you can, and costs related to merits. To the extent you can break them down, it's helpful, or make at least some allocation, even if it is a rough allocation.
And when you say itemize the costs, when we think about that, we often think about very detailed bills, which often raise questions of privilege and individual time entries, which I assume you do not want.
No. I would expect saying Debe Voice $300,000 or $315,000, and White and Case.
Today's cost.
Debe Voice $300,000.
Yeah, something like that. And you say then expert. Well, expert A, $50,000. Expert B, traveling expenses, $200,000. Organizing the hearing, $300,000. Payments to ICSID, $600,000. That you itemize them so that we can have an idea of how you, and then that you then represent that these are the truly incurred costs. I would expect a representation from you that these costs are real.
To assist Mr. President, just to be concrete, we would suggest a cover letter no more than 1 page and a summary table along the lines the president just described. We were going to suggest 1-page summary table, but if it assists for practical reasons to say up to 2-page summary table, that would be okay. And that clearly is a summary table that's just just the facts. And we would propose a date. We were going to say January 7th, actually, but if you want, December 31st.
January 7th, that is one day after the holy magi, and it's a very appropriate, in Spanish-speaking world, a very appropriate day after the finalizing of the holiday period. So yeah, 7th sounds good to me if it sounds good to Mr. Friedman.
Okay.
Yes. May I, and I think what we should do in what Mr. Hamilton is describing in principle sounds fine. I would suggest that it sounds like we should talk about it a little offline, but come up with something along those lines. That is short submissions that don't provide a lot of detail, but that are then certified as to their accuracy by the council, which, may I, Mr. President, just—
And without reopening Pandora's box, so to speak. It's a cost submission and nothing more.
Yeah,
right.
Yeah. Please don't, because we will evaluate them and we'll then make an analysis of them. I don't think that I would discourage you, let me say it that way, that we then have a round in which you then comment on the other party's submission. I don't, to be very frank, I don't think that would be more cost, and it would not be extremely helpful to the tribunal.
We couldn't agree more. That's, if I may, Mr. President, there's just one sort of matter of housekeeping that it really, I regret to raise, but I was reminded of it, and it did come up today in respondents' submissions. As you know, there were a number of 10 authorities that we had proffered to the tribunal with our post-hearing brief on jurisdiction. Tribunal reserved on those. There are two in particular that I think may now be relevant and that you should take account of in light of respondent submissions today. The first of them is Renko 2, which was the other case against Peru under the same treaty. Ms. Menaker referred to that in some detail in her slides, and so I think it's appropriate, and it's in the public sphere anyway. I think it's appropriate that that come in. The second one is Ms. Menaker also referred to the annulment decision of the Canadian courts in the metal-clad case. That's an authority and that's not in the record, but if it's an annulment on a relevant issue of a case that a party is relying on, we don't really have an objection to you taking account of what the reality of the state of the law is. But by the same token, you should probably take into account the annulment in the Clorox case on which respondents have relied, because that was annulled on the very issue that they cited it for. So I just wanted to bring those two legal authorities to your attention, because I do think equality of arms would sort of allow you to, and maybe require you to, take account of them in light of respondents' legal submissions today.
Mr. President, if I might, equality of arms would have meant that they followed the rules, that Gramercy did not repeatedly break procedural rules, did not repeatedly stuff into the record improperly in violation of tribunal orders, additional evidence at the wrong periods of time, did not sandbag with additional documents, did not bring out new authorities, did not repeatedly try to change Professor Edwards' submissions. All of it has been violative of due process. I'm sorry he raised this. Putting in extra cases now, we did not get the opportunity to put in 10 new cases that we felt like. There are many new things that we might observe to continue to undermine Gramercy's case. And so simply to let in what they want because they unilaterally decided, they unilaterally violated the rules. They not only unilaterally violated the rules, they didn't even follow the proper procedure, something they had already been scolded for in the past by the tribunal. So unfortunately, there's no equality to, I can cram in what I want, I can break the procedural rules, and then we'll try to sort of squeeze it in this way later and call it equality. It is not equality, Mr. President. That is why we have rules. And if they want to crack it open, we will go to town with new cases. We could have put in 10 new cases. We could put in 15 new cases. So that is the difficulty before the tribunal. We would be very glad, for example, to allow the United States government, the non-disputing party, which we've made our views clear on how it has been treated in this proceeding by Gramercy. We're sure they would have views on Renko too, but they never were given a chance to do so. So all of these are the problems with a claimant who breaks the rules. And I'm sorry, but just trying to, at the last minute, get us to cave on their repeated procedural violations doesn't work for all the reasons that we have articulated. So we're sorry that the tribunal has been put in this uncomfortable position. We did not create the circumstances. We're simply trying to cope with the circumstances.
Well, Peru did assert a new jurisdictional objection at the post-hearing brief stage, which is what
that is
prompted
true
the
because of your withholding of relevant evidence over time. I'm sorry that this is happening at the end of the case, Mr. President, but if claimant continues to bring up issues like this, we're going to continue to push back as necessary to protect the state. I'm sorry about it.
Mr. Hamilton, let me ask Ms. Menaker. I remember you spoke about Ranco 2.
Yes, I'm sorry, is that your question? Yes,
yes.
I did address it.
Okay, I don't remember whether you wrote, you spoke about the annulment of metalclad.
Yes, I did and let me just say, when I spoke about Ranco 2, I did also reference the dissent, right, which was put in.
Did you speak about?
Metalclad, I did, it was, it's not on a slide, I just mentioned it in response to an argument about the pre-publication rule in Peru allegedly having been violated, and that would constitute or could constitute a fair and equitable treatment violation. And I was making the argument that domestic violations are not necessarily equivalent to international violations, and particularly in the context of transparency obligations like that, even if they are found in another provision of that same treaty. And that was an issue that was before the British Columbia Supreme Court many years ago in the metalclad case, where that case was partially set aside. So I mentioned that.
Yeah. And did you mention the annulment of Clorox?
No, I didn't. That was a case that we had relied on earlier, and that was what Gramercy mentioned, that case had been annulled, I believe, by the Swiss the Swiss courts in their post-hearing brief. They mentioned that.
Okay.
I don't know if my colleague Jonathan Ulrich, if he addressed.
Let me finish with you, if I may, Ms. Menaker. So Ranco 2, do you know if it is in the record?
It is not in the record. It was one of the cases.
Do you mind, since you have referred to it, would you mind sending us a copy of Ranco 2? So that it is in the record.
The claimant, I believe, already has, because it mentioned it in its post-hearing brief. Then after that, because it was a new authority, Peru wrote in complaining that they had introduced new legal authorities, and the tribunal said it will keep it there and it would decide the issue at the end of the hearing. So that's what
I know, Menaker. My question is very specific. Since you have referred to it now,
yes.
You presumably do not mind to bring it into the record. We can do it in 2 ways. We can validate what the claimant has done, or you can send to us the Ranco 2 copy, whichever you prefer.
Well, Mr. President,
no, Mr. Hamilton, let me finish, please, with Ms. Menaker. Do you mind?
And so you understand that you have the authority from the post-hearing brief, and you're asking me
if you agree that we use it, Ms. Menaker. You have referred to it. Since you have referred to it, the other party has brought it in. Is there any objection on your side that we have a look at it? It is very difficult to, let me say how the world works. I go into the internet, I type in Ranco 2, I will read it and then see if what you have said makes sense to me or not, because I cannot validate your...
I understand, Mr. President.
And so it is a purely formal question whether these decisions, which are in the public domain, whether we incorporate them or not. So if we can be flexible, let's just say, let's incorporate it. It's what the claimant wants and you have used it. I don't think that there should be any problem with that.
And
Mr. President, you leave us no choice. I'm sorry to say, we're left with no choice. This is what happens, and I'm watching the smirks and chuckles of opposing counsel that cram these things into the record specifically for this reason. They briefed it. It's in their briefs, which have never been published on the internet. It's in their briefs. We never got a chance to brief it. So I'm sorry, but this is why people should follow the rules. So we're basically left with no choice, Mr. President. We're left with no choice.
Ms. Menaker
Renco 2.
Mr. Hamilton, Ms. Menaker did refer to Renco 2.
She did it
on your slide.
But we did it specifically because the issue has been left hanging out. There's been no ruling on it. They've already briefed it. It's sitting in their briefs together with 10 other sources that they were not authorized to use. We followed the rules. So I'm sorry, this is exactly the problem with rule breaking. And it's exactly why it's not okay. I understand the tribunal wishes to make reference or to take notice of Renco 2 together with the dissent, together with the position of the non-disputing party, the United States, which agrees with the Republic of Peru about the interpretation of the treaty. So under the circumstances, we understand you're saying you're going to read it anyway. So
no,
we don't know what else we can say.
But Mr. Hamilton, this is not reasonable. Ms. Menaker, you have, it is in your slides.
By necessity, because they put it into their briefs. So we're left with no choice. That's yes, my point.
But now you have chosen to react to Renco 2. And now you have made some arguments on Renco 2. How do you want us to validate Renco 2 if we don't put it into the record? I just don't see the reasonability now of not putting it into the record, Mr. Hamilton.
I think that it's unreasonable that they broke the rules and put us in this position. But in any event, we understand that the tribunal is going to take notice of the entirety of the Renco 2 package that I mentioned at this point in time.
Okay. And
I'm sorry to sound stubborn, but I'm simply applying the rules that apply. I apologize. I'm sorry that we've all been put in this situation again.
I fully understand your point, but the position is that Ms. Menaker has now referred to these two decisions. And so to some extent, this is now, this is object of dispute between the parties. And I think this is Renco 2 and the annulment of Metal Clad. You referred to these two decisions. They are not in they were in these documents which claimant wanted to introduce into the record. You objected to that, but now you have reacted to these two. So I don't know how you want to solve this, Mr. Hamilton.
As I mentioned, Mr. President, I think that respondent is left with no choice. I think that the bottom line is that Renco has been put improperly into the record. It's been improperly briefed by counsel that I've been watching smirk through this conversation. And therefore respondent, because it had not been excluded, addressed it. And so I understand the tribunal is asking for the submission of Renco 2 together with the dissent and the position of the non-disputing party. And that would be it. And we understand that all the other unauthorized materials submitted by Gramercy will be excluded. And we understand that we are not to submit any new materials by respondent either.
Excellent. So we all agree on that, I think.
Well, no, I think Mr. Hamilton smuggled a few things into that answer, purporting to be an agreement, which we don't all agree on. It's quite clear that Ms. Menaker referred to Renco 2. And look, the tribunal will, the legal authority that you can get on the internet. I just really don't understand the position. Second, the issue with the metal-clad annulment was that wasn't an authority that we had proposed you take a look at. It's one that Ms. Menaker, for the first time today, I think suggested bore on one of the issues that she was pleading about. And she said that's relevant because we had relied on an aspect of metal-clad tribunal decision that she then said was annulled. So if you should take account of that, which we aren't fighting on this. We aren't resisting the idea that if they wanted to, it's a one authority, if they wanted to send you the metal-clad annulment to make good what she said during her speech today, we don't really have an objection to that. But by the same token, we had cited the Clorox annulment case, which is one of the 10 that we had proposed that you take a look at, because that was a very recent annulment decision by the Swiss courts on the issue for which respondent was relying on it. So that's a kind of equal treatment. And I really have resisted going tit for tat on this idea of Gramercy and Debevoise are rule breakers. I absolutely resist it. I think that it was absolutely incredibly against all of the rules to try to assert a new jurisdictional defense for the very first time in a post-hearing brief when all of the evidence on which they made that argument were available to them well beforehand, certainly well before the hearing and in time for all of their last briefs. It's simply, I mean, that's a gross violation of the rules. And most of the authorities that we presented to you were simply in response to that if you get past even a threshold looking at it, given what the clarity of the UNCT trial rules. So I don't want to argue the point. It's not productive. It's late in the day and we should have said our thank yous and congratulations and goodbyes already. But I did want to just make sure that the housekeeping issue is fairly put and that you have it in front of you.
Very good. We'll do the following. Let us go through we have to go through the record and we'll see whether these cases, including Renko, metal clad annulment and Clorox annulment, whether they are relevant for our decision. And now I must remind our secretary and Crystal and the assistant to the tribunal that if we find that they are relevant, we will tell you. And if you want to say anything about these cases, which are in the public domain, you are more than welcome to do that. Hopefully you will not have anything to add, but we will solve it in this way. And hopefully we will not need these cases. If we need them, we will let you know and we will give you an opportunity to speak. But we must, the only problem with this is that we must remember that to do that, and we must leave a note somewhere at the beginning of the award so that we do not do this without giving some thought. And if we are to use any other case which is not in the record, we will also let you know so that you can make arguments.
Mr. President, I appreciate the effort. I must say, though, that your comment puts a foot in the door to actually closing the record of this case and opens the scenario that there are going to be more letters, more exchanges. And I think that at least 15 minutes ago, we were trying to stop all of that. So we would be very content to run this to ground right now and be done with it, because otherwise we can't do cost submissions. We don't know what people are going to be drumming up to put into some letter in 3 months from now. We can just close the issue right now. We're glad to do it and end the letters and end the uncertainty and end, all these procedural issues. And then you never have to hear, we never have to hear each other again about this.
Then let's all agree. Let's all agree. Renko 2, annulment of metal clad and annulment of Clorox, we put it into the record. That makes the life much easier. Let's just say these are 3 publicly known decisions. Let's put them into the record. That's the easy solution, and we solve this problem forever. If not, we'll go the other way. And I give you the choice, Mr. Hamilton. You choose one way or the other.
Our choice is that Gramercy should have followed the rules, but in any event, we will accept your compromise solution.
You cannot.
Which is I understand an effort to wrap it up. So, Ms. Miniker, do you have any other comment?
No.
A no to my proposal or a no to no further comments? Don't.
No to no further comments. I am
okay
with your proposal.
So you agree we put these three decisions into the record?
We do not object to the tribunal's choice to take notice of them, given the circumstances that have been created by the conduct of claimant. Thank you.
Okay, so can I ask the secretary and the assistant, can you put a number to these 3 decisions? Just get them down from the internet, put a number to them and inform the parties, and we close this. Excellent, thank you. Thank you for that. It would not
I only
have
say I
been,
never had a chance
it
to
would
say
not
thank you and
have
be
been
nice.
a fitting end to this case if we had not had this discussion on these three documents. It is a fitting end, and I think it is also a fitting end that we have found a solution. So no further ado, it is now 8:30 in Europe, and you have to go to lunch probably in the States and in Canada. Thank you to all of you, and I hope to see you safe and healthy very soon in person. Thank you. Bye.
Thank you, everybody.
Thank you. Thank you,
Thank you,
Dr.
everyone.
Stern, Mr. Dreimer, Mr. Armesto. Thank you very much.
Empanadas.
Hasta luego.
Empanadas next time. Yes.
Hasta luego todos.
Hasta luego.
Gracias.
Bye
Muchas
bye.
gracias, señor presidente.